Part 5. Further thoughts. The first legal system. For some years I taught a law school seminar on legal systems very different from ours. The central idea was a simple one. All human societies face about the same problems. They solve them in an interesting variety of different ways. There is no good reason to think that we are wiser than other people in other times and places, so all of those solutions ought to be taken seriously not as historical curiosities or primitive practices but as ways in which a group of adults tried to solve the same problems that we attempt to solve with our legal system. I am not trying to figure out what is the best legal system indeed, I doubt there is one. I am simply trying to understand how different systems worked, what problems they raised, how they dealt with them. I invented the course as a commitment strategy, a way of forcing myself to learn things, and it worked. For most of what I have learned you will have to read the book based on that course that I am currently writing. This chapter is about one particularly striking conclusion. The legal system I invented 40-some years ago and described in part 3 of this book is less imaginary than I thought and much older. What I reinvented in the context of a developed modern society was a more elaborate version of the system on top of which many, perhaps most, of the legal systems of the world were built. That system was stateless and decentralized, and its basic logic was quite simple: if you wrong me, I threaten to harm you unless I am compensated for the wrong. There is one requirement such a system must satisfy to function as law enforcement rather than extortion: that my threat to harm you is more believable if you actually have wronged me than if you have not. There must be some reason why right makes might. That requirement has been met in a variety of different ways in different societies. In Saga period Iceland, the most organized such system that I have looked at, what converted right to might was the existence of a legal code and a court system. Once a court had outlawed you for failing to pay me damages, everyone else in the society knew that you were the one at fault, with the result that my friends would support me in any subsequent conflict and your friends would not support you. For details, see chapter 44. The legal system of the Roman Chal gypsies, the largest gypsy group in modern-day England, is a more primitive version of the same system. If you wrong me, I threaten to beat you up if not compensated. Both of us know that, if you have wronged me as judged by the customary rules of our society, my friends will back me and yours will not back you. Hence if you are in the wrong you either compensate me or leave town. There are many other examples of societies, past and present, whose legal system works on the same principle. Most enforce traditional rather than legislated law. Most have some formal mechanism for settling disputes, some equivalent of my arbitration associations. In some, such as the Icelandic, enforcement is by the victim and an ad hoc group of his friends, relatives, and allies. In others, such as the traditional legal system of Somaliland, the northern part of Somalia, the coalition that supports an individual in such a conflict is created by an explicit, sometimes written, contract specifying in advance the obligations that the members of the coalition have agreed on, a rights enforcement agency in a society with less specialization and division of labor than ours. In still others, such as the Bedouin, the coalition is defined almost entirely by kinship, membership in a tribe or its subgroups. Just as in our system, while law is enforced by the threat of violence, actual violence occurs only when the threat fails to work. Despite the popular image of a blood feud with a long chain of revenge killings, actual feuds in such systems usually terminate quickly. A feud system, feud not feudal, the words are unrelated in both meaning and etymology, may or may not be better than the alternatives, but it is an approach to law enforcement that has functioned successfully over long periods of time in many societies. One of the things I concluded about feud systems was that they are the foundation on which a variety of other legal systems were built, as demonstrated by the existence within the later systems of the fossilized remnants of the earlier. Traditional Jewish law provides one striking example. If you killed someone, were tried, found guilty of the equivalent of first-degree murder and sentenced to be executed, the sentence was supposed to be carried out by the avenger of blood, the heir of the person you murdered. If you were found guilty but of a non-capital killing, you were to be escorted to one of the cities of refuge to remain there until the high priest died in exile of uncertain length. If, however, the avenger of blood caught up with you on your way to the city of refuge, he was free to kill you. Pretty clearly, that is what was left of a system in which, when a man was killed, it was the right and duty of his heir to avenge him. Further evidence from Jewish law is the rule forbidding the avenger of blood from accepting a money payment to let the killer off. The fact that there is a law against something is pretty good evidence that it is something people do, or would do if the law did not exist. In this case, the law was blocking the payment of wergeld, the damage payment for killing that, in a feud society such as that of Iceland or Somaliland, was used to prevent the revenge killing that would otherwise occur. Another example of fossilized feud is provided by Islamic law, which treats killing or injuring someone not as a crime against the state but as a tort against the victim. If the offense is a capital killing, the kin of the victim are entitled to retaliate. They have the option, however, of instead accepting diya, the Arabic wargeld, a fixed payment, specified in camels, to compensate the kin for the killing, or of accepting a smaller payment, or no payment at all. If the offense is only an injury, the victim has the option of accepting a fixed damage payment whose amount is specified in law, agreeing on a smaller payment, or simply forgiving the offense. Pretty clearly, this is a remnant of Bedouin feud law adopted by Mohammed into his legal system. The two most important modern examples of legal systems built on the ruins of feud law are European civil law, based on Roman law, itself based on a feud law whose remnants can be seen in the Law of the 12 Tables, and Anglo-American common law. The latter evolved out of an Anglo-Saxon legal system similar to the Icelandic through a process in which the king claimed that certain offences were violations of the king's peace as well as of the rights of the victim, hence that the offender owed damage payments to both. Feud law, in substance although not in form, is alive and well in modern-day America. Consider high-tech patent litigation, where the potentially profitable wrong of suing someone who has probably not violated your patents in the hope that you can persuade a judge or jury that he has is deterred by the threat that he will retaliate in kind. The mechanism by which right makes might in that context is provided by a court system which makes it harder to win a case when you are in the wrong than when you are in the right, although perhaps not hard enough. The most notable failure of that system is the problem of non-practicing entities, referred to by their critics as patent trolls, firms that buy patents in order to sue or threaten to sue other firms that it claims infringe them. Patent trolls do not themselves produce anything, so cannot be countersued, so are immune to retaliation. For a solution to that problem borrowed from Periclean Athens, whose legal system I like to describe as the invention of a mad economist, you will have to read my next book. Anarcho-capitalism, the kindergarten version. Explanations of economics sometimes start with Robinson Crusoe on his island, go on to add Friday, and from there expand to a more complicated and realistic economy. The equivalent for physics is to analyze the trajectory of a point mass moving in a vacuum or a hockey puck on a frictionless table. In this chapter I apply the same approach to the explanation and defense of a stateless legal order. My objective is not to produce a realistic description of what such an order might look like in a modern society. That was the project of part 3 of this book. It is rather to answer, in the simplest possible way, the arguments of those who claim not only that such an order would not work but that it cannot work. A proof is destroyed by a single counter-example. If I can describe a working stateless order, even in a much simpler society than ours, then a proof that such an order cannot work must be wrong. Imagine a society where population densities are low enough so that everyone knows most of his neighbors, as would have been the case, outside a few cities, in the 13 colonies in the 18th century. It is a society sufficiently homogeneous so that most people agree, most of the time, on fundamental moral issues that theft and murder are wrong, that people are obliged to fulfill their contracts, and the like. That does not mean that nobody will choose to rob or kill. People are good at finding exceptions in their own favor to the moral rules they otherwise agree with. But it does mean that, faced with an accurate account of such an action by someone else, most people will reach the same conclusion as to whether it was right or wrong. Finally, make it a society without a government. I believe that you have stolen my cow. I publicly complain and ask you to return the animal or compensate me. You deny that you are guilty. I could proceed to threaten you with the use of force, threaten to shoot your cow, even to shoot you, if you refuse my demand, but that would be imprudent. Our neighbors would have no way of knowing whether I was punishing a guilty offender, punishing someone I mistakenly believed to be guilty, or engaged in extortion under pretense of defending my rights. Some of them might help you in the resulting conflict, many would be cautious in the future about dealing with me. One of them might even decide that I was a public danger, especially if I went ahead and killed you and removed me. Instead of threatening you, I demand that you submit our dispute to a neutral arbitrator, someone who has the reputation in our community of being honest and competent. I offer, if the arbitrator rules against me, to compensate you for your time and trouble. I ask you to agree that if he rules that you did steal my cow, you will return the cow or its equivalent and compensate me for the trouble you have put me to. To make the offer more attractive, I add that I am willing to consider an alternative arbitrator if you want to suggest one, provided he has the same reputation as the one I propose. The reason I do all of these things is not that I want to be sure I am acting justly. As it happens, I am quite sure you stole my cow, having seen you go off with it. The reason is that I want to make the offer attractive enough so that if you were innocent you would accept it. If you refuse, our neighbors will conclude that you are guilty. Not only will they not object to my threatening force against you, they may offer to help, since you might steal one of their cows next. If you accept, the arbitrator rules against you, and you then refuse to pay me the damages he adjudges, they again conclude that you are the guilty party, again accept, perhaps assist, my use of force against you. It follows that if you are guilty and I can prove it to a neutral arbitrator, your only practical option is to pay up. This is a very simple society, but it contains most of the essential features of a more realistic one. Criminals exist and are restrained not by moral pressure but by the threat of force. There are good faith disagreements about who owes whom what, but they can be resolved by arbitration. Once you have agreed to an arbitrator, lost, and refused to pay up, the disagreement will no longer be viewed by others as in good faith. What important features have I left out? One is the problem of information. How do third parties, or for that matter defendants, know which arbitrators are to be trusted? How much do my neighbors know about how I have conducted myself in the past, hence how they should regard me in the future? These are the same problems that separate a toy model from a more realistic one in the context of ordinary markets. In the world as it is, still more in the world as most libertarians, including those who are not anarchists, want it to be, I still face the problem of deciding which doctors, which teachers, which car repairmen, which computer manufacturers, to trust. We solve that problem in part by word-of-mouth reputation, in part by professional intermediaries, a university that hires the teacher and has a reputation it wants to maintain, consumer reports, rating agencies of various sorts. Part 3 of this book described what the intermediary institutions in the market for rights enforcement and dispute resolution might look like. A second problem I have assumed away is serious disagreement over what rights people have and who has them. Do women have the same rights as men? At what age do children get to be treated as adults? Are there slaves with greatly reduced rights, defined either by race or by their history perhaps, as in classical antiquity, captured in war or sold for debt? Given enough disagreement over such issues, it might be impossible to find an arbitrator who was acceptable to both disputants and most of their neighbors. But then, given enough disagreement over such issues, any society, any legal system, is likely to have problems. Disagreement over the last, in the US, resulted in 4 years of warfare with enormous loss of life and destruction of property. In Chapter 44 I described a society, Saga period Iceland, intermediate between the toy society I have just been describing and the modern stateless order I sketched in Chapter 29. It had a legislature and a court system, so did not depend on the sort of informal and decentralized legislation/adjudication I have been describing. But enforcement was entirely private. It was a feud system where the ultimate sanction was private force. Iceland twice faced a large-scale conflict over religion. The first, in the year 1000, was between Christians and pagans. It was settled by arbitration after violence in which perhaps half a dozen people were killed. Compared to similar conflicts elsewhere in Scandinavia under something closer to central royal authority, it was an extraordinarily peaceful outcome. The second was the conversion from Catholicism to Lutheranism, forced by the King of Denmark nearly 300 years after the end of the Icelandic Commonwealth. That time about 10 times as many people were killed out of a smaller population. Proofs about how alternative legal or social or economic systems will work are hard to come by. But that evidence at least suggests that a decentralized legal system may be able to settle fundamental conflicts somewhat more easily than a centralized system. One possible reason is that it has less need of uniformity for many, although not all, issues. It can let different people function under different rules. One of the terms of the settlement of the original Christian/pagan conflict was that, while Christianity became the official religion, private pagan worship was still permitted. Bargaining into anarchic order. A long time ago, my friend and colleague Gordon Tullock wrote a chapter for a book on anarchy in which he argued that it was impossible to bargain one's way out of Hobbesian anarchy, the war of each against all. His argument was simple: until you had a state there was nothing to enforce contracts, so any agreement you reached had no effect. I concluded that the argument was both obvious and wrong. As anyone who knew Gordon would understand, the opportunity to say so, if possible in print, was one I could not resist, so I wrote a review of the book. This chapter is based on the argument of that review. Arnold and Bill are the only inhabitants of a small Hobbesian anarchy: no government, no customs, no pre-existing rules. It occurs to both of them that their situation has serious problems. Anything one of them gathers the other might steal, and spending full time guarding things makes it hard to gather more. A possible solution is for one of them to kill the other. Adequate precautions to prevent that will make it hard to do much else. There should be a better way. Arnold proposes one. There is a stream running through the forest. He will take one side of it for his territory, Bill the other side for his. Each will agree not to trespass on the other's territory without permission. The agreement will be enforced by the threat of violence. Arnold makes it clear that if he finds Bill on his side of the stream after they have agreed to the division, he will do his best to beat him up, and that he expects Bill to behave similarly. A fight to the death is likely to be a losing proposition even for the winner, so each has a clear incentive to abide by their agreement, provided that each believes the other is committed to enforcing it. Arnold and Bill have just created private property in land. They have done so by reinventing territorial behavior, a survival strategy practiced by various species of animals, mostly birds and fishes. Territorial animals mark the territory they claim and enforce their claim to it by a commitment strategy, by somehow turning a switch in their brain that makes them attack a trespasser of their own species more and more fiercely the farther into the territory he comes. Unless the trespasser is much larger than the defender, a fight to the death is a loss for both, so once the trespasser realizes the defender is committed to fight, he retreats. Time passes. Arnold locates a grove of apple trees, clears out the surrounding undergrowth and harvests the fruit. Bill has found an outcropping of flint, chipped himself an axe, and is using it to cut down some trees in order to build a hut he is tired of being rained on. One day Bill notices Arnold, on his side of the creek, watching him work, and comes over to chat, politely leaving his axe behind. Arnold has a deal to propose. If Bill will cut down several large trees currently shading the apple grove, Arnold will promise to give Bill a bushel of apples from each year's harvest. Bill agrees to the deal and performs his part of the contract. Arnold considers the possibility of reneging on his picking a bushel of apples is a fair amount of work and, once picked, he would rather eat them himself than hand them over to Bill. It occurs to him, however, that Bill still has an axe and can use it, if he wants, against Arnold's apple trees the next time Arnold is somewhere else. Or, if he prefers, against Arnold. He decides to deliver the apples as per contract. The reason Bill gets the apples is not that he has cut down shade trees but that he can cut down apple trees once the contract is agreed to. It is the threat, not the past performance, that makes Arnold deliver. Why couldn't Bill have saved himself a considerable amount of work by starting with the threat, telling Arnold that he will cut down the apple trees unless Arnold pays him a bushel of apples not to? How, if at all, does making the initial agreement and performing Bill's half of it change the strategic situation? The answer requires a brief digression. Shelling points, the idea. A professor calls a student into his Yale office and asks him to participate in an experiment with the possibility of a reward. The objective is to rendezvous with another student in New York City by both being at the same place at the same time. If they succeed, they will each get $100. Neither knows the other's name and, even if he guesses it, they are not permitted to communicate before meeting. To win the prize, each has to guess where and when the other will try to meet him. One way of doing so is to figure out what time and place each will see as unique, since if their criterion for choice yields more than one answer they might choose different answers and so miss each other. Time is easy given our system of timekeeping. Noon and midnight are the only times that appear unique. Which they choose will depend on how long it takes them to get from New Haven to New York and what hours they normally keep. If it does not take too long and they are not night owls, noon is the obvious choice. Where is harder? When I first read about the problem, my suggestion was the top of the Empire State Building. That was, at the time, the tallest building in the world, making it unique in a fairly obvious sense. It turned out, however, that there was no such place. The building has 4 observation decks spaced around the 4 sides, with no obvious way of deciding which one to meet it. I am told that in the real-world experiment, proposed by Thomas Schelling some 50 years ago and later implemented by someone else, the students met under the clock at Grand Central Station, to them the obviously unique meeting place. At noon. This is a story about coordination without communication. What makes it relevant to this chapter and much else is that describes not only situations where you are unable to speak to each other but also situations where you can speak but neither party has a good reason to believe what the other says. For that version of Schelling's idea, replace our 2 Yale students with 2 bank robbers. Having pulled off a successful heist they must decide how to split the loot before going their separate ways. If they argue about it for too long the police may show up. Each played a different role in the robbery and each believes that his contribution was larger than that of his accomplice. I predict that they will split the money evenly, not because either thinks that fair but because that is the one division that both see as unique, hence as an alternative to interminable bargaining. They can talk to each other, but if one insists that he will not agree to any division that gives him less than 60% of the money the other has no reason to believe him. 50-50 is different. The same analysis applies to a wide variety of bargaining situations. Both parties are better off reaching agreement, each would prefer to do it on terms more favorable to himself. The longer they bargain, the less the benefit to be shared between them. In the case of the bank robbers, that is represented by the risk that the cops will show up. In union/management bargaining, lost wages and revenue during a strike. In bargaining over a treaty to end a war, lives lost and property destroyed. The logic of all three situations is the same. Shelling points, the application. The deal by which Arnold and Bill established their mutual property rights was a result of the shelling point provided by the stream that they chose as their boundary. Bill could have tried to insist on getting everything on his side of the stream plus a strip on the other side. Arnold could have made a similar demand. They could have tried to divide the territory on some other basis, drawing an arbitrary line determining what each got. Any of those alternatives would have raised the same problem faced by the bank robbers haggling over their loot. For any offer Bill can make, Arnold can make a counter-offer more favorable to himself. If they bargain too long, they may starve or one of them may lose patience and take a convenient opportunity to brain the other. The stream provides a division that is simple, unique, already defined. Before the apple contract was made, Bill could have tried to extort apples from Arnold. Doing so would have created a bargaining situation, a mutual threat game. They have a common interest in Bill refraining from using his axe on either Arnold or Arnold's orchard. They have a conflict of interest over how many apples Arnold pays Bill. The one shelling point in that strategic situation is for Bill to respect the original division of the land, leaving Arnold with all his apples. Once Bill has performed his half of the contract, there is a new shelling point for Arnold to pay Bill a bushel a year, as agreed. The agreement has changed the situation not because either party considers himself morally bound to keep his word but because the agreement changes the structure of the alternatives as both perceive it. A different way of looking at the situation is to say that both Bill and Arnold have an incentive to establish a reputation for keeping their contracts, since that will permit further cooperation in the future. The discipline of constant dealings discussed back in Chapter 29 when I was explaining why firms would abide by their arbitration agreements. But we now have the tool to look into the question a little further. Suppose Arnold reneges on his contract, pays no apples, and somehow gets away with it. Next year Arnold again wants Bill's help. Bill's response is proverbial: "Fooled me once, shame on you, fooled me twice, shame on me." Arnold explains that he is wrong. It is true that Arnold broke his word once, but that was last year. Arnold explains that his policy, his consistent policy, is to break his word the first time, keep it forever after. Why does Bill refuse to believe him? Because always keeping your word is a unique policy, a shelling point. Keeping your word from the second year on is no more unique than keeping it on every other year, or every third year, or days when it doesn't rain. No more unique than breaking it the first 2 years and then keeping it, and this is the second year. Shelling points help us understand why the discipline of constant dealings works, because people perceive always keep your word as a unique policy, hence a shelling point on which bargainers can converge. I believe I have now shown why Gordon Tullock's claim that, absent a government to enforce contracts, making a contract has no effect, hence individuals cannot bargain their way out of a Hobbesian anarchy, was mistaken. Making the contract changes the strategic situation by changing the pattern of shelling points. Contracts are, to at least some degree, self-enforcing. A positive account of rights. During the time men live without a common power to keep them all in awe, they are in that condition called war, and such a war, as if of every man, against every man. Thomas Hobbes. In the previous chapter I showed how it might be possible, in a toy society of two people, to bargain up out of a Hobbesian state of nature into an orderly and peaceful micro-society. In this chapter I apply the same approach to the world as it actually exists, a society in which large numbers of people interact, for the most part peacefully and cooperatively. In the process, I hope to provide answers to a number of different questions. 1. What are rights, considered not as a moral or legal category but as a positive category, a description of how people act? 2. How is it possible for civil order to exist? Why are not all people, all of the time, in the Hobbesian state of nature, the war of each against all? 3. What is government? What distinguishes it from other human institutions? And, as a free bonus, 4. Why did the UK send a fleet most of the way to Antarctica and risk its only aircraft carrier in order to defend a cluster of barren islands with a few hundred people on them? Part of the answer to question 3 appears in Chapter 28, written more than 40 years ago, but I believe that I understand it better now than I did then. The puzzle. Thomas Hobbes described the state of nature as a war of each against all, in which the life of man would be solitary, poor, nasty, brutish, and short. That does not sound like the world we live in. His solution was to establish an all-powerful ruler. That comes a little closer to the real world, but not all that close, and it is not clear how it could be done or why it would work. In the state of nature, each individual acts in his own interest. That sounds like a reasonably accurate description of our world. How is his improved version, the world with a ruler, different? The ruler is not Superman. He too must sleep and can be killed while doing so. He may have a police force and an army, but police forces and armies are made up of men. What causes those men to act differently than they did in the state of nature? Where does the structure of an orderly, peaceful society come from? What is the magic ingredient that distinguishes civil order from the state of nature? It cannot simply be laws. Laws are words on paper and only take effect to the extent that individuals act on them. Why should individuals act differently after laws are passed than before? It cannot be police in uniforms and judges in robes, in Hobbes' day wigs as well. Uniforms, robes and wigs do not confer magic power on their wearers or compel their wearers to act differently than they would without them. That is the central puzzle that this chapter attempts to answer. Neighborly extortion. Imagine that you live in a suburban neighborhood with a not terribly efficient or well-organized law enforcement system. One day your neighbor calls you over to the fence for conversation. He explains that he finds taking his trash down to the town dump every week to be a nuisance and has decided that it would be less trouble to simply dump it over the fence onto your property. When you recover your breath and start lecturing him on property rights, he offers you a simple cost/benefit analysis of your alternatives. Dealing with his trash will take about $10 or $20 worth of your time and effort every week. Persuading the city authorities that the trash is his and not yours, getting them to do anything, appearing for multiple court hearings, raising a fuss, will cost you the equivalent of considerably more than that. But, he adds, he has an alternative proposal. For him to dump the trash and someone else to collect it is clearly inefficient. A better solution is for him to deal with his trash and you to pay for it. For a mere $5 a week, half or less what your lowest cost solution to the problem would cost you, he will agree to refrain from dumping the trash over the fence. I predict that you will turn down his generous offer, tell him to go to hell and, if he persists in dumping his trash on your property, spend the equivalent of considerably more than $5 a week, or even 10 or 20, prodding the relevant authorities into doing something about the problem. Why? The answer is a fancier version of the territorial behavior discussed in the previous chapter. You, like a territorial bird or fish, have adopted a commitment strategy, more complicated than theirs because what you are committed to defend is not a territory but a set of rights. There are things you consider yourself entitled to in your interaction with other people, and one of them is not having trash dumped on your property. In defense of those rights you, like the territorial animal, are willing to bear costs out of proportion to what is immediately at stake. A different way of putting the point is that, if you give in to your neighbor's attempt at small-scale extortion, there is no obvious limit to how far it will go. There are, after all, quite a lot of other ways in which he, or other people, could impose costs on you or demand payment not to. By adopting a policy of resisting such demands even at considerable cost, you give other people an incentive not to make them. If they do not make them, you do not need to bear the cost of resisting them. What prevents your neighbor, following the same logic, from committing himself to bear large costs if you do not give in to his extortion? The short answer is that you will not believe him. The long one is that you are defending a Schelling point created by your, and his, perception of individual rights. Given the existence of only one such Schelling point, one settlement of your potential conflicts that appears unique to both of you, it makes sense for you to defend it just as it made sense for the bank robber in our earlier story not to accept any offer for less than half the loot. The logic of the situation does not depend on the existence of either law or shared moral beliefs. All it requires is that both of you know what rights you claim and both of you know that the claim is unique, that you cannot believably insist that your rights consist of no trash plus his paying you a modest tribute any more than he can insist on the same terms the other way around. A little more on Schelling points. A crucial point here is a feature of a Schelling point that I did not make explicit in my previous discussion, the fact that its existence is a subjective, not objective, feature of reality. It is a feature of how the interacting parties view the world. To make the point clearer, imagine that two people are presented with the following list of numbers and offered a prize if they succeed, without communication, in both selecting the same one. 2, 5, 9, 25, 69, 73, 82, 100, 126, 150. Each of them, as per the previous discussion, is looking for a number that is unique. But which numbers are unique depends on how each of them thinks about numbers. To many ordinary people, 100 is a round number in a sense in which the others are not. To a mathematician, all that is special about 100 is that it is an exact square and the list contains 2 others. It may, however, occur to the mathematician, assuming he is coordinating with another mathematician, that in the entire set of positive integers there exists only one even prime, making it the obvious choice. To someone who is illiterate and sees the numbers only as patterns, 69 will seem unique for its symmetry, conveniently letting him coordinate with someone whose interest is more prurient than mathematical. There is no objectively correct number. It depends on how the person you are coordinating with thinks. For a somewhat more strained example of the same point, go back to our bank robbers, with one difference. Because they come from a society dominated by utilitarians, they have been taught to measure value not in dollars but in utils, units of happiness. Furthermore, everyone in their society believes that the marginal utility of income is inverse to wealth, that someone with twice as many dollars values each additional dollar at exactly half as much. To these philosophical robbers the obvious division is still 50-50, an even split, but it is an even split of utility, not money. One of them happens to be twice as wealthy as the other, so an even split, one that gives him half the utility, must give him 2/3 of the dollars. What the two robbers agree on is not how much each one is morally entitled to. We can assume, as before, that each believes he did more than half the work and so deserves more than a half share. We could even assume that both agree which one of them did more than half the work. Provided that they do not agree about how much more, that agreement does not generate a Schelling point to coordinate on. A 50-50 split does. I emphasize this point because one possible explanation of social order is morality, individuals refraining from murder, rape, and robbery because they believe such actions are wrong. That is a possible explanation, but not the one I am offering here. My claim is that even without moral agreement, even without any moral belief at all, a pattern of consistent commitment strategies makes coordination possible. Escaping the state of nature. I have now offered a solution to the puzzle I started with. What is added to a state of nature in order to turn it into civil order, to convert the war of each against all into peace, is a network of commitment strategies based on an elaborate set of mutually perceived Schelling points. It could be based on shared religious or ideological beliefs but need not be. What matters is that each person is committed to bearing substantial costs to maintain his commitment strategy, that people for the most part correctly perceive each other's commitment strategies, and that those strategies are for the most part consistent, that I am not committed to getting from you something you are committed to not giving me. The ways in which individuals enforce their commitments will vary with context. In the previous chapter it involved the actual use of force, whether against people or trees. In my tale of suburban extortion, the weapons were more likely to be lawyers than axes. But in both versions and many others, it is the pattern of commitment that gives order to the society and the existence of a commonly perceived network of Schelling points that makes possible that pattern of commitment. Why Hobbes was wrong. One implication of this way of viewing an orderly society is that Hobbes was wrong. A society may have no all-powerful sovereign, even no sovereign at all, and still be a great deal more orderly than he imagined. The clearest real-world examples would be primitive stateless societies such as the Comanche. They had nothing we would recognize as a government, but killing a man or seducing his wife had consequences due to the commitment strategies of other members of the society, consequences that made such actions much less common than they would be in Hobbes' version of the state of nature. And why Hobbes was right. The same view of human behavior shows why Hobbes' solution, if not necessary, is at least possible. His version of an orderly society, ruled by an all-powerful sovereign, is supported by a different pattern of commitment strategies and Schelling points. It is a pattern in which individuals are committed to resist what they see as rights violations by most other individuals but not similar actions by the sovereign or his agents, and in which the relations of the sovereign and his agents are structured into a hierarchy of authority by their own self-consistent network of commitment strategies. For a simplified version, suggested to me long ago by the late Earl Thompson, imagine that the ruler can successfully commit himself to kill any of 3 subordinates if they defy his orders. He orders each of them to make a similar commitment to control 3 of their subordinates. Continue the cascade until there are enough people in it to believably threaten any of those outside the ruling clique who, since they are not committed to defy such threats, will yield whenever yielding is less costly than resisting. Each individual, inside and outside government, is acting in his own rational self-interest given what everyone else is doing, making it what game theorists describe as a Nash equilibrium. A positive account of rights. This way of looking at behavior provides a way of understanding rights that depends on neither law nor morality, although it might be reinforced by either. The fact that I have a right not to be killed means neither that killing me is wicked nor that it is illegal, only that it will usually not be in other people's interest to do it. That particular right is enforced by the commitment strategies of other people in the Icelandic society described in Chapter 44, the commitment of my kin to use violent force against anyone who kills me and refuses to pay them the wergeld that the court awards. More generally, my rights are whatever I am successfully committed to defend, where success depends in part on other people recognizing my commitment and having no commitment of their own that directly clashes with it. What is government? What is anarchy? This approach provides a clearer answer to that question than I was able to give in the first edition of this book. A government is an institution against which people have dropped the commitment strategies that defend what they view as their rights against other people. An anarchy is a society in which there is no such institution. An anarchist is someone who sees such a society as desirable. All of that was, I think, implicit in Chapter 28, where I defined a government as an agency of legitimized coercion. But I understand it more clearly now. And what the British Navy was doing in the Falklands. This way of looking at individual behavior also explains some of the behavior of governments. Argentina's invasion of the Falkland Islands triggered a British commitment strategy: respond with force to anyone seizing British territory. Britain responded by sending a fleet most of the way to the South Pole to get the islands back. It made very little sense viewed in immediate cost/benefit terms. It would have been a great deal cheaper to transport all of the inhabitants to England and give each of them enough money to support him for the rest of his life. But it made a great deal of sense given that defend our boundaries was a Schelling point and defend our boundaries except when Argentina invades the Falklands was not. Credits. In addition to Thomas Schelling, the ideas of this chapter owe most to the late Earl Thompson, possibly the most brilliant not very famous economist I have known. An economics Nobel of my acquaintance, not related to me, once described him as having the highest IQ of anyone he knew. It was Earl who first convinced me of the importance of commitment strategies in understanding human behavior and the structure of human societies. Credit also goes to Gordon Tullock for provoking me into thinking through the ideas, as described in the previous chapter. Market failure, an argument for and against government. A field such as physics or economics has its own vocabulary, technical terms used to describe ideas. One problem in talking about such a field or teaching it is that the terms often sound self-explanatory. I am sure there are lots of people who believe that they really understand the theory of relativity, except for the mathematical bits. The theory of relativity says that everything is relative. I understand that. The theory of relativity does not say that everything is relative. On the contrary, it says that the speed of light is so absolute that it appears the same to every observer, however fast he is moving relative to the light source. It was that simple and apparently impossible fact, demonstrated by the Michelson-Morley experiment, on which the theory was built. The same problem exists in economics. Competition sounds as though it should describe something like a chess game or a horse race, with each competitor trying to beat out his rivals. Such a situation exists in fields with only a small number of companies: Microsoft vs Apple, Apple vs Google, Ford vs GM. Economists call it imperfect competition. What we call perfect competition is a market with many firms, each so small that it can ignore the effect of any other firm on it and its own effect on the market. The wheat market is perfectly competitive, the auto market or the cell phone market is not. The same problem exists with market failure. It sounds as though it means a situation in which the market fails, for whatever reason, to do something we would like done. But that is not what it means, or at least not what it should mean. Consider a simple example. In 1908 something, possibly a large meteorite, struck Siberia, producing the equivalent of a multi-megaton nuclear explosion. The failure to evacuate the target area was a failure. Since it could have been done by the voluntary acts of those living there, it could be described as a failure of the market. But it was not a market failure as the term ought to be used, since there was no way at the time of anticipating the event. Not all failures of the market count as market failure. Equally confusing, not all market failures occur on the free market. Conservatives and libertarians sometimes describe the political equivalent of market failure as government failure. But where a failure of the political system is due to precisely the same logic as a corresponding failure of the economic system, it makes more sense to describe it as market failure on the political market. There is no central authority for defining technical terms, and if there were, I would not be running it. But I hope to convince you, in the course of this chapter, that my definition of market failure is more useful, leads to clearer understanding, than any definition limited to what we usually call the market. A market failure is a situation where individual rationality does not lead to group rationality. If each individual makes the right decision, the group makes the wrong decision. In the extreme case, every individual ends up worse off than if each of them had made a different decision. For one of my favorite examples, imagine that it is 1,000 years ago somewhere in Europe. I am one of 5,000 men with spears, lined up facing south. The reason we are facing south is that another army, also with spears but on horseback, is coming at us from that direction. I do a very quick cost-benefit calculation. If we all stand our ground, some will die, but, with luck, we will break their charge and most of us will live. If I run, horses run faster than I do. It looks as though I should stand. I have just made a mistake. I only control me, not we. If I stand and everyone else runs, I die. If everyone else stands and I run, reducing our army by one is unlikely to make much difference to the odds, and, if their charge is stopped, I won't be one of the ones who dies stopping it. If the line does break and run, I will at least be in the lead. Whatever the rest of the army does, I am better off running than standing. Everyone else makes the same calculation, we all run, and most of us die. Welcome to the dark side of rationality. Readers who have studied economics or game theory have probably already encountered the simplest version of market failure, a two-person game called Prisoner's Dilemma. Two criminals, Bill and Joe, have been arrested for a crime jointly committed. The DA has enough evidence to convict them of a minor offense but not of a serious crime. He makes Bill the following offer. If you confess and Joe does not, I will let you off with a slap on the wrist, 3 months in prison, a suspended sentence for the rest, and send him up for 5 years. If he confesses and you don't, he will get the suspended sentence and you will be the one who gets 5 years. If you both confess, you will end up with 3 years each. If you both refuse, I will give up on the major charge and get you for a year on the minor. He makes the same offer to Joe. If Joe confesses, Bill gets 3 years in jail. If he too confesses, 5 if he does not. If Joe does not confess, Bill gets a year if he remains silent, 3 months if he confesses. Either way, he is better off confessing. The same logic applies to Joe. Whatever Bill does, Joe is better off confessing. Both confess and they get 3 years each. If they had both remained silent, it would have been only 1. Yet neither of them has made a mistake. For a third example, consider a market failure I observed repeatedly when I was teaching at UCLA. Just south of campus was the intersection of Wilshire and Westwood, about 10 lanes each, claimed by the locals to be the busiest intersection in the world. At rush hour, cars on Wilshire trying to get across Westwood and not quite making it filled the intersection, blocking the cars on Westwood trying to cross the other way. Gradually the cars in the intersection filtered out, just in time to let enough cars on Westwood into the intersection to block it the other way. If everyone had followed a policy of not pulling into the intersection unless he was sure he would be able to get through it, everyone would have gotten home sooner. But any individual who acted that way would as a result have gotten home later. The problem in all 3 cases is the same. Someone is making a decision that affects both himself and other people. He makes the decision on the basis of the effect on him, everyone else acts similarly. He gains from his decision, loses from theirs. The loss is larger than the gain, so on net he, and everyone else, is worse off than if they had all acted differently. Economists describe such a situation as an inefficient outcome due to an externality. The actor ignores the external cost his act imposes on others and so takes an action which, if all costs are taken into account, ought not to be taken. If everyone makes the opposite choice, everyone, at least in my examples, is better off, but each individual is better off if he makes the choice that is in his interest. A different example of the same logic was discussed back in chapter 34. Something could be produced, in that example a dam for flood control, that would benefit all the members of a pre-existing group of people. The producer had no way of controlling who got the benefit, so could not, as with ordinary goods, make getting the benefit conditional on paying for it. The result was that the dam might not get built even if its value was greater than its cost. Market failure, as I hope I have convinced you, is a real problem. Although imperfect solutions can sometimes be found, I described some back in chapter 34 and could have described others. There is no guarantee that goods worth producing will get produced, that armies will stand and fight instead of running away and being slaughtered, that traffic intersections will not jam. I hope I have also convinced you, with my choice of examples, that it is not a problem limited to the free market. It can occur in any situation where individuals are making decisions that affect both themselves and others. Considered as an argument for government. The central assumption of economics is rationality, that individual behavior can best be predicted by assuming that each individual takes those actions that best achieve his objectives. Obviously, the prediction will not always be correct. Not only do I observe other people sometimes making mistakes, I observe myself making mistakes. Even though I know I am overweight, bowls of potato chips in my near vicinity tend to mysteriously empty. I know myself well enough to predict my irrationality and try to deal with it by not having bowls of potato chips too near. But although rationality is not a perfect description of human behavior, it may be the best assumption available for predicting the behavior of large numbers of strangers. Point 3. Rationality looks like a convincing argument in favor of institutions in which individuals are free to make their own choices, yet most economists are not anarchists or even libertarians. One reason they are not is that, even if each individual correctly acts in his own interest, the result may be worse than if each was compelled to do something else. For economists, that is the standard justification for many, perhaps all, government actions. Public goods are underproduced, so tax people to pay to produce them. Not only national defense, as discussed back in chapter 34, but scientific research as well. Negative externalities are overproduced, so regulate pollution, tax the production of carbon dioxide to reduce global warming. Positive externalities are underproduced, so subsidize education. In some specific cases the argument is weaker than it at first appears, a point I will return to in chapter 64. But the underlying logic is correct. It follows that even rational individuals can sometimes be made better off by restricting the choices they are permitted to make. One response sometimes offered by libertarians is to deny the existence of market failure. There is a better one. Market failure as an argument against government. Back in chapter 39, I discussed the problem of rationally ignorant voters. Someone who takes the time and trouble to figure out which candidate will be best for the country and vote for him is producing a benefit that will be shared with all his fellow citizens, a public good. Rational ignorance is the underproduction of that public good. In chapter 38, I described various government activities as legalized theft, benefiting one actor at the expense of another, and used the concept of rent-seeking to show that the result might well be to make everyone, including the politicians, worse off. When you work to pass a law that benefits yourself at the cost of other people, you are producing a negative externality. Negative externalities are overproduced. Market failure exists on the ordinary private market. Its existence implies that we could sometimes be made better if a sufficiently wise and benevolent authority made some of our decisions for us. But, in the real world, the alternative to laissez-faire is not ruled by a benevolent and supremely competent dictator, it is having decisions made on the political market instead of the private market. Market failure exists because individuals are making decisions much of whose cost or benefit goes to someone else. That situation sometimes occurs on the private market, but there it is the exception, not the rule. Most goods are ordinary private goods, so the producer can convert much of the benefit to the buyer into a benefit to himself via the price he charges. Most production uses inputs: labor, raw materials, capital, land that the producer can only use if he compensates their owners for what they give up by letting him use them. In the standard model of perfect competition, which assumes away problems such as public goods and externalities, what the producer is paid for a good for turns out to be just what it is worth to the purchaser, what he buys inputs for to be just what they are worth to the seller, hence his private benefit is precisely equal to the social benefit, the total effect of his actions summed over everyone. That is a simplified model of a market economy, but at least it is a first approximation. Individual actors usually receive most of the benefit and pay most of the cost of their actions, making market failure the exception, not the rule. On the political market, individual actors, voters, politicians, lobbyists, judges, policemen almost never bear much of the cost of their actions or receive much of the benefit. Hence market failure, the exception on the private market, is the rule on the political market. Which suggests that the existence of market failure is, on net, an argument against government, not for it. Anarchy and efficient law. In the society described in Part 3, law enforcement and law are private goods produced on a private market. Law enforcement is produced by enforcement agencies and sold directly to their customers. Law is produced by arbitration agencies and sold to the enforcement agencies, who resell it to their customers as part of the bundle of services they provide. Enforcement agencies want to provide their customers with legal rules the customers like. Arbitration agencies want to provide legal rules that enforcement agencies want for their customers. The result should be good law. In this chapter I use the concept of economic efficiency to make more precise what that means. Having done so, I will show in what ways the legal rules produced by the market for law may be inefficient, less good than the rules that would be designed by a benevolent and perfectly wise legislator. It is, in the language of the previous chapter, an explanation of market failure on the market for law. The concept of economic efficiency, although not the term, goes back to Alfred Marshall, who put together modern economics a little more than a century ago. It was his solution to the problem of how to decide whether a benefit to one person does or does not outweigh the loss to someone else. It is an imperfect solution, for reasons briefly described in chapter 43, but a useful one since, unlike more philosophically satisfactory approaches, it is an objective that economics tells us a good deal about how to achieve. The idea, as earlier explained, is simple. We measure the benefit to someone of any change by the largest amount he would pay to get it, the cost by the largest amount he would pay to prevent it. The net effect of any change is the sum of all benefits, positive, and costs, negative, to everyone it affects. A change is an improvement if the sum is positive, a worsening if it is negative. We describe an outcome as efficient if there remain no ways of changing it that would be improvements. Seen from the standpoint of the rights enforcement agencies, the argument I have already offered implies that the market for law will generate efficient law. If a change in the legal rule between two agencies benefits both, it is in the interest of the arbitration agency to make it so as to improve the quality of the product it sells. If it benefits one agency by more than it hurts the other, it is in the interest of the two to agree on the change, with the agency that supports it compensating the other either in cash or by agreeing to accept its preference on some other issue where the preferences go the other way. It follows that the legal rules the arbitration agency produces should maximize the net benefit to the agencies. Whether it also maximizes net benefit to their customers is a more complicated question, for at least two reasons. Monopolistic competition in the law enforcement market. In the perfectly competitive market of the economics textbooks, many producers produce identical products that are perfect substitutes for each other. When I buy a bushel of wheat or a barrel of oil, I do not care which firm made it, with the result that firms end up selling identical goods at the same price. A firm that charged more would sell nothing. Contrast that to the market for computers. A Macintosh and a Windows computer are not perfect substitutes, some people prefer one, some another. If they happen to sell for the same price, some customers will buy the Mac, some the PC. If the Mac gets a little more expensive, a few customers, the ones an economist describes as marginal, will switch, but most will not. Like an ordinary monopoly, Apple can vary its price over some range, trading off higher prices against fewer sales. But because PCs are substitutes, although imperfect substitutes, how many machines Apple can sell at what price depends in part on the price of the alternative. This is what economists call monopolistic competition. It is a common market pattern, one somewhat more difficult to analyze than the simpler case of perfect competition. Suppose Apple, which is currently selling its machines at the price that maximizes its profits, is considering some improvement, perhaps a faster processor, that will increase both the cost of making the machine and its value to the customers. The increased value means that Apple can raise its price and still sell as many machines as before. But how much it can raise the price without losing sales depends not on the value to all customers but on the value to the marginal customers. So far as the customers who greatly prefer Mac to Windows are concerned, Apple could have raised its price before if it knew who they were. But raising the price for everyone would have lost its sales to the marginal customers, which is why it did not do so. Suppose the increased speed is valuable only to the enthusiasts. In that case, even if the total value to the enthusiasts is greater than the cost to Apple of the improvement, Apple will not make it, since the value to the enthusiasts is irrelevant to how much Apple can sell its computers for. If, on the other hand, Apple makes an improvement that is valuable to the marginal customers, for whom it increases value more than it increases cost, it pays Apple to make the improvement even if it is of no value to the enthusiasts. It follows that it may pay Apple to make some changes whose total value, considering all of the customers, is less than their total cost and fail to make some whose total value is more than their total cost. The design of Apple's computers has some tendency towards economic efficiency, towards the design that maximizes the value to the customer's net of the cost of making them, but an imperfect tendency, since it is based on value only to marginal customers. By offering different models tailored to different segments of its market, Apple can reduce the problem but not eliminate it. Rights enforcement agencies are also in a monopolistically competitive market. Just as with computer companies, the amount an agency can get its customers to pay is an imperfect measure of the value of its services to them since it depends only on the value to the marginal customers. Like Apple, the agency can try to tailor its services and prices to the different requirements of different customers and so come closer to collecting from each the highest price he is willing to pay. But unless it can do so perfectly, it will not collect all the value, so there may be changes in what it provides, including the legal rules it agrees to, that increase or decrease its revenue by more or less than they increase or decrease the value of its services to its customers. It follows that although the market has some tendency to produce efficient law that maximizes the benefit to those who live under it, the tendency is imperfect. The desires of marginal customers are weighted more heavily than those of customers who strongly prefer their agency to any of its competitors. Externalities: market failure in the market for law. We can expect the legal rules between agencies A and B to maximize their joint welfare. We can expect the rules to maximize the joint welfare of all of their clients, subject to the problem I have just pointed out. But we cannot expect the rules applying between A and B to take into account the effects of those rules on customers of other enforcement agencies. So we can expect the result to be optimal only when the legal rule between A and B produces no net effect on customers of other agencies. In many cases this is plausible. The rule that determines what happens if A breaks his contract with B or breaks into B's house or breaks B's arm should have little effect on C. But consider intellectual property law. Imagine that Anne, a computer programmer, is bargaining with Bill, a consumer, for Bill's agreement to pay Anne $10 for each copy of any of her computer programs that Bill makes. The benefit to Anne of receiving $10/copy is exactly balanced by the cost to Bill of paying $10/copy. If these were the only costs and benefits, agreement and disagreement would be equally efficient. But there are at least two other costs. One is that Bill will make fewer copies of the program than if copying were free. Perhaps he will put a copy on his desktop machine but not on his laptop. Perhaps he will buy copies of 2 of Anne's programs but not a third, since that one is worth only $5 to him. This is the familiar deadweight cost of copyright, the inefficiency due to the difference between the positive price of making an additional copy to the user and the zero marginal cost to the copyright owner of permitting an additional copy to be made, resulting in an inefficiently low number of copies. A second cost is the cost of enforcing the agreement. Keeping track of what copies Bill has made will be costly, perhaps impossible, and any resulting dispute may lead to expensive litigation. To balance these costs there is a benefit: the programs that Anne will write if she expects to be paid for them and won't if she does not. If we were considering the effect of requiring all consumers of Anne's intellectual property to pay for it, that benefit might well outweigh the costs we have described, making copyright protection for programs economically efficient. If Anne does not write any programs there will be nothing for Bill to copy. But we are considering the question not with regard to the whole world but only with regard to Bill. The additional revenue Anne will receive as a result of Bill being obliged to respect her copyrights will produce only a very small increase in output. That increase will benefit everyone who uses Anne's programs, but only the part of that benefit that goes to Bill will be relevant to the negotiation between them. He is, however, bearing all of the cost of using fewer programs than he would if he had not agreed to respect Anne's copyrights, and she is bearing all of the costs of enforcing that agreement against him. It follows that the net benefit to them of an agreement between them is almost certainly negative. That may still be true from the standpoint of their enforcement agencies, which are the ones actually negotiating. Bill's agency will take into account not merely the benefit to him from the increased output due to his being bound by Anne's copyright but the benefit to all of its customers due to the increased output from all of them being bound by Anne's copyright. The result is still only a small fraction of the total benefit from the agreement, assuming that there are many enforcement agencies each serving only a small part of the population. The fraction becomes larger if we allow for the possibility of copyright negotiations among groups of enforcement agencies, with each agreeing to recognize the copyrights of the customers of all of the others if they will all agree similarly. Such negotiations would be analogous to the negotiations among nations by which international intellectual property rights are now established. Even allowing for such multi-party negotiations, our result, although weaker, still remains: we would expect an inefficiently low level of protection for intellectual property. We might well get no protection at all. This raises two questions, both outside the range of this chapter. One is whether intellectual property protection is desirable at all. Readers interested in arguments that it is not will find them in Against Intellectual Monopoly by Michelle Baldwin and David Levine. The other, whether the equivalent of intellectual property protection could be provided in other ways, for instance by contract, is discussed in the context of digital intellectual property and encryption in My Future Imperfect. A similar situation will exist for pollution law, where Anne's right to sue Bill for polluting her air results in a reduction of Bill's emissions and thus an external benefit for Anne's neighbor Carl. It may exist in other important contexts as well. In all of these cases, we would expect the legal rules generated by the private market to be less than perfectly efficient. They should still be better than the rules generated by political mechanisms under our current system, since we have little theoretical reason to expect those legal rules to be efficient at all. From that standpoint, this chapter is offering a special case of the argument of the previous chapter. Market failure sometimes exists on the private market. On the political market it is the rule. Default rules, economies of scale, and the stability problem. The first edition of this book got one good review, defined not as a favorable review but as a review that makes the author think. The reviewer was James Buchanan, later my colleague at the Public Choice Center of VPI. The review, while generally positive, pointed out a crucial hole in my analysis of a stateless legal system. This chapter is my attempt to fill it. Back in chapter 29, I considered the case of two rights enforcement agencies whose customers disagreed about a legal rule, with customers of one supporting and of one opposing capital punishment. Each agency calculates how much it is worth to its customers to have their preferred rule apply to disputes with the customers of the other. The agencies then bargain, whichever is willing to offer more to get its preferred rule gets it. My conclusion, which I qualified a little in chapter 54, was that the result would be an efficient set of legal rules in the usual economic sense, a set of rules that maximized the summed benefit to all affected. There was one question that I forgot to ask: what is the default rule, the starting position that the parties are bargaining from? In order for the agency that wants capital punishment to get its preferred rule, does it have to pay the other agency to agree to have capital punishment, or only turn down the other agency's offer to pay it to agree not to? One way of answering the question is with another. If no agreement is reached, what happens? The obvious response is that, if no agreement is reached, the two companies will be, in the terminology of the Icelandic sagas, out of law with each other. Each conflict between their customers will have to be settled by ad hoc bargaining or violent conflict. That suggests that one important determinant of the terms of agreement, if agreement is reached, is how well each side thinks it would do under those circumstances. To put the point differently, underlying the market for law is an implicit threat game. The worse I expect to do if it does come down to violence, the more willing I will be to either agree to your terms or pay you to agree to mine, the less likely I will be to insist on doing it the other way around. There is a sense in which the rules of any society are built on an underlying threat game of the same sort. There are always potential conflicts, with the government or without it, over the legal rules and the rules that determine the legal rules. If one faction finds current rules sufficiently unsatisfactory, there is always the potential recourse to force, whether in the form of civil war, domestic terrorism, or merely large-scale private violation of the law. The point was demonstrated most recently by the antics of the Occupy movement, which engaged in various illegal activities as a way of pressing for what its members saw as desirable change. It was demonstrated on a larger and much more violent scale by recent conflicts in Libya and Syria. Seen from this point of view, one can view the social contract not as a voluntary agreement, which it obviously is not, but as a peace treaty. Each individual and group in the society has things it believes it is entitled to. Some of those claims are inconsistent with each other. Slaveholders believe they are entitled to own and control their slaves, and some others believe they are not. Libertarians believe that freedom of association gives everyone the right to refuse to hire, serve, rent to anyone he wishes on any grounds he wishes, including race. Liberals believe that everyone has the right not to be discriminated against on illegitimate grounds, such as race. A multitude of other examples, different for different societies at different times and places, could be offered. Each person knows that he does not have sufficient resources to compel everyone else to grant him everything he believes he is entitled to. An actual society, a civil order, embodies a set of compromises, giving each participant enough of what he wants and believes he is entitled to get so that he does not find it worth trying, with his allies, to forcibly overthrow the system and substitute one closer to his desires. One of the things determining just what that set of compromises is will be the ability of the various factions to win a civil war if it happens, to successfully violate legal rules its members disagree with but others want and get, to win out if the order breaks down. In that sense, a mutual threat game underlies not only the stateless order I proposed in Part 3 but every society. Libertarians, going back at least to Lysander Spooner, find a social contract insufficient as a justification for state action. So do I. A peace treaty is a contract formed under duress. My moral intuition, like current law, fails to see such a contract as binding. If a mugger points a gun at me and offers me the choice of my money or my life, it may be prudent to give him my money. But I have no morally binding obligation to do so, no obligation to tell him about the money that is not in my wallet but my money belt. Viewing the social contract as a peace treaty formed in response to the implicit or explicit threat of violent conflict explains what it is but does not give it moral force. The implication of this analysis for my proposed stateless society is that rights enforcement agencies are producing two different sorts of products, only one of which was included in the analysis of Part 3 of this book. That one is the service of enforcing rights, negotiating legal agreements, settling disputes. The other is the service of threatening other enforcement agencies in order to get the legal rules their customers prefer on the best possible terms or, alternatively, to make sure that if they do not get them they get compensated for going along with the terms preferred by the customers of other agencies. It follows that my reasons for believing that economies of scale in the industry will not be sufficient to produce very large firms are weaker than I thought. Even if economies of scale in rights enforcement and related activities are not sufficient to produce large firms, economies of scale in the ability to threaten other agencies might be. Judging by the historical record, economies of scale are common in that industry. God is often, as Napoleon is supposed to have said, on the side of the big battalions. If so, the equilibrium size of agencies might be large enough, the number few enough, to threaten the stability of the system, to create a risk that government will be re-established by a cartel of rights enforcement agencies. Possibly a worse government than we started with. This should be an issue mainly in the early stages of a stateless society, when the legal system is forming. Judging again by historical evidence, there is a lot of inertia in the equilibrium of mutual threat games. National borders do not shift out by a few miles every time a country launches a new battleship or increases its military budget. Once the system has established itself and legal rules have been agreed on between each pair of agencies, they should be reasonably stable against non-consensual change, due to the same forces that established stability in the two-person society of Chapter 51 and the larger society of Chapter 52. An agency that insists on changing the rules without offering adequate compensation will be seen as an aggressor to be resisted even at substantial cost, enough of a danger to other agencies to generate a defensive coalition against it. The Schelling point is the status quo. If so, enforcement agencies in an established stateless order should be primarily producing rights enforcement for their customers, which means that their efficient size will be mainly determined by the technology of that industry. With luck, agencies will be sufficiently small and sufficiently numerous to make a cartel unlikely, bringing us back to the optimistic conclusion of my earlier discussion. But they may still keep a few tanks in the basement, just in case. The hard problem, Part 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. U.S. Constitution, Second Amendment. When I wrote Chapter 34, more than 40 years ago, I described national defense as the hard problem. Its logic has not changed and it is still hard, although less hard now that the Soviet Union no longer exists as a threat. But I have had additional thoughts since then of ways in which it might be solved. They are based on an odd variety of sources: the Second Amendment to the U.S. Constitution, paintball, the Society for Creative Anachronism, the open source movement, and a short story by Rudyard Kipling. I will start with the Second Amendment. As I interpret the relevant history, the Second Amendment was intended as a solution to a problem strikingly demonstrated in the previous century. Oliver Cromwell, in winning the First English Civil War, had shown that a professional army could beat an amateur army, which was a good reason to have one. By winning the Second English Civil War he demonstrated something else a professional army could do and ruled for 5 years, until his death, as Lord Protector of the Commonwealth of England, aka military dictator. That was a good reason not to have a professional army. Damned if you did, damned if you didn't. The solution hit upon by the founders was a compromise, a kludge. Combine a small professional army with a vast amateur militia consisting of all adult men of suitable age. In peacetime, give Congress and the professionals the job of producing enough coordination so that, in time of war, the state militias and the regulars could function tolerably well together. The Congress shall have power to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively, the appointment of the officers, and the authority of training the militia according to the discipline prescribed by Congress. Article I, Section 8. If the professionals tried to seize power, they would be outnumbered by about 300 to 1. In case of war, the large size of the militia combined with the skills of the regulars would, with luck, make up for the militia's low quality. It was an ingenious solution and one that worked, judged by the non-existence so far of either foreign conquest or military coup. A similar solution might work for a stateless society. It too requires some way of dealing with foreign aggressors. It too faces the risk that a military sufficiently formidable to defend it might be formidable enough to seize power. It, unlike a state, faces the additional problem of funding a military without tax revenues. Amateurs are cheaper than professionals. Cutting your cost per soldier in half does not solve the problem of paying for the military if you need more than twice as many soldiers, but reducing it to zero does. Which brings in the next element of my plan. I know quite a lot of people who not only train to fight without being paid, but pay the cost of their own equipment to do so. For many years I was one of them. It is true that our equipment, consisting of swords, shields, and armor, would be of little use in modern warfare or medieval warfare, given that the swords are made out of rattan, not steel. But if the same resources of time, energy, and money were put into similar training with more up-to-date equipment, the result would be an amateur army, a militia numbering 10,000 or so, a first small step towards an adequate military. The Society for Creative Anachronism, which fields armies of upwards of 1,000 fighters aside for its annual Pensic War, is one part of a much larger picture, people who engage in military exercises for fun. The sport of paintball, in which I have not participated, is another. The weaponry and skills are much closer to those relevant to modern warfare. Paintball is sometimes used by the US military for training. The number of people involved is also somewhat larger. According to industry estimates, more than 10 million people in the US played paintball at least once in 2006 and almost 2 million played at least 15 times a year. Expenditures for equipment came to about $400 million. That is getting towards the numbers required for an adequate militia. Paintball and SCA combat are fun and exciting. They could be even more fun if there was more of a point to them, if the participants believed that in addition to playing a game, they were also training to protect themselves, their loved ones, the society they lived in. Structure the institutions right and you have the labor for your militia and at least part of the gear for free. Not that different from the militia contemplated by the Constitution. Which gets me to one of Rudyard Kipling's odder stories, The Army of a Dream. The narrator has just returned to England after an extended absence. An old friend, a military officer, explains the changes to him. The central one is very simple. War games, the kind you play in field or forest at a scale of an inch to an inch, have replaced football and cricket as England's most popular sport. Public schools compete with each other in fake battles refereed by volunteers from the military, with bets on the outcome. I should say it was, said Pigeon suddenly. I was roped in the other day as an adjustment committee by the Kemp Town Board School. I was riding under the Brighton racecourse, and I heard the whistle going for umpire the regulation, 2 longs and 2 shorts. I didn't take any notice till an infant about a yard high jumped up from a furze patch and shouted, "Guard! Guard! Come here! I want you professionally! Alf says we ain't outflanked. Ain't he a liar? Come and look how I've posted my men." You bet I looked. The young demon trotted by my stirrup and showed me his whole army, 20 of them, laid out under cover as nicely as you please round a cowhouse in a hollow. He kept on shouting, "I've drew Alf into there. His position ain't tenable. Say it ain't tenable, guard." I rode round the position, and Alf with his army came out of his cowhouse and sat on the roof and protested like a militia colonel, but the facts were in favor of my friend and I umpired according. Well, Alf abode by my decision. I explained it to him at length, and he solemnly paid up his head money farthing points if you please. Kipling is not describing an anarchist society. The initial training is compulsory and the system is elaborately interwoven with the professional military. But a central part of his vision is a society where learning military skills is something people want to do, enjoy doing, and get social as well as governmental rewards for doing. We're a free people. We get up and slay the man who says we aren't. But as a little detail we never mention, if we don't volunteer in some corps or another as combatants if we're fit, as non-combatants if we ain't till we're 35 we don't vote, and we don't get poor relief, and the women don't love us. The result is a society that can field an enormous army if needed but does not have to spend an enormous amount to create and maintain it. It is, of course, the army of a dream. Then it came upon me, with no horror, but a certain mild wonder, that we had waited, V and I, that night for the body of Boy Bailey, and that V himself had died of typhoid in the spring of 1902. The rustling of the papers continued, but Bailey, shifting slightly, revealed to me the 3-day-old wound on his left side that had soaked the ground about him. Combine Kipling's imagined picture with the observation that millions of people already engage in military games and military training for fun. Add in the institutions of open-source software 5 the system that produced Linux, the third most popular desktop operating system, as well as the Apache software that a majority of web servers run on. Open source software is developed by volunteers, mostly unpaid, for a mix of non-pecuniary reasons, to get the programs they want, to get prestige with their peers, to demonstrate their coding ability to potential employers. It provides a striking example of how sophisticated voluntary production in a non-market context can be. Individual military equipment may be paid for by the individual hobbyist, but not many enthusiasts can afford a tank, an artillery piece, or whatever the equivalent will be in the military technology of the future. Companies, on the other hand. Every April 15th, the platoon fielded by Apple Computer marches in the Liberty Day parade led by a robot tank flying Apple's banner, clear evidence that Apple is a responsible and patriotic company whose computers, and phones and tablets and watches, you should buy. Microsoft tries to do them one better, parading its larger platoon, also employee volunteers, under a swarm of armed robot drones. I have offered a rough blueprint for fielding a very large militia at a very low cost. There remains the problem of coordination, of how to get millions of volunteers divided into thousands of independent units to work together. For that we require professionals funded, as many functions are funded already, by charity. It should not take too much charity, since we do not need very many of them. We are back with the military structure of the Second Amendment, a large militia of amateurs, a small cadre of professionals. In peacetime the professionals provide services to the amateurs, possibly for pay, making sure that all their communication devices can talk to each other, refereeing their mock combats, encouraging some degree of standardization of parts and ammunition. In war, if there is a war, the professionals make up the top cadre of officers. I do not want to overstate my argument. When trying to analyze how imaginary institutions would work, certainty is in short supply. I have sketched one way in which a stateless society might defend itself. How well it, or other alternatives that have not occurred to me, worked would depend in part on how serious the threat was. When I wrote Chapter 34, the threat was a Soviet Union allied to China, both equipped with arsenals of nuclear weapons. That was one of the reasons I was not at all sure that a future American anarchy could defend itself. Today the situation is rather different. Before the first Gulf War I added up the GNPs of the two sides. The odds were just about 100 to 1. Currently, the nearest thing the US has to a serious enemy is Iran. Its GNP is about 1/50th that of the US and it is a long distance away. Mexico and Canada are closer, but neither seems likely to invade us. In that respect, the situation has sharply improved. A second factor, one hard to predict, is the culture of the stateless society. The mechanism I described assumes a society most of whose inhabitants approve of it, want to defend it. Without that condition, it might work much less well. On the other hand, that mechanism shares with the original system of the Constitution one important advantage over a more centralized system: the army it creates is poorly suited to pull off a military coup. The militia is made up of a multitude of different groups with different views and loyalties, and it outnumbers the professionals 100, perhaps 1,000, to 1. Initial appropriation, a brief venture into moral philosophy. While I, like everyone else, hold views about right and wrong, I do not believe I have any way of showing that those views are correct. I can try to tease out the structure of my beliefs by introspection. I can attempt to construct an internally consistent account of them, and similarly for what I can deduce about other people's beliefs. But since I cannot show that my beliefs are true, arguments based on them strike me as less useful for persuading reasonable people of my political conclusions than arguments that use economics to deduce the consequences of the institutions I favor and try to show that those consequences are desirable in terms not only of my values but of the values of those I wish to persuade. Moral arguments are still interesting. It is particularly interesting to try to see whether and how the institutions I favor can be justified in terms of my own normative beliefs. This chapter offers two different approaches to doing so. It is based on an old article of mine responding to an article by Barrick Brody, a philosopher of generally libertarian inclinations. His piece attempted to justify a moderate amount of income redistribution along libertarian lines. My response first reinterpreted his argument, something that only became clear from his response, and then offered an alternative. I will start with my interpretation of his argument, then go on to my alternative. Both have the same objective: making private ownership of land, in particular the right of owners to exclude others, consistent with some version of libertarian moral theory. They are thus possible responses to a problem that I raised in the introduction and touched on again in Chapter 41, the problem of justifying ownership of unproduced resources. First try, Brody as revised by Friedman. One ought generally to respect other people's rights, but, as I argued back in Chapter 41, Not always, if the consequentialist gains from a rights violation are sufficiently large and the violation itself sufficiently small, the violation is justified. Earlier examples included stealing something when doing so was the only way of preventing a catastrophe that would wipe out the human race, and using a rifle against the wishes of its owner when doing so was the only way of preventing mass murder. As mentioned briefly in that discussion, such a rights violation establishes a debt. I ought, if possible, to compensate the owner whose rights I have violated. The surface of the earth was not created by any human being, so nobody starts with a right to exclude any other human from any part of it. It follows that such exclusion is a rights violation. It is, however, highly desirable that individuals be able to own land and exclude others from it, since without private property in land the ways in which land can be used are very limited. The argument of the previous paragraph suggests that it is therefore proper to convert land into private property, but that the claimant is obligated to compensate the people whose rights he violates by doing so. In Barrick Brody's version of the argument, the exclusion was a rights violation in the distant past, when the property was first claimed. In my, I think improved, version, it is a current rights violation. My front yard is by nature a commons, since I did not create it, so keeping you out of it is a violation of your rights. So is keeping you out of my living room, or at least out of the land my living room sits on. If I am violating your rights, I owe you compensation. In Brody's view and, in a similar discussion, Robert Nozick's, the compensation need not take the form of an explicit transfer. Land as property is a great deal more productive than it would be as a commons, with the result that there are more things available at lower cost, which is a benefit even to those who do not themselves own any land. Arguably, that provides fair compensation to almost everyone. But if there is anyone who is worse off in a world of private property than he would be if everything were treated as commons, he is owed compensation by those who gain from the existence of property in land. Thus this argument appears to justify some very minimal level of redistribution. While that is a possible reading of the moral implications of enforcing private property in land, it is not one that fits very well with the redistribution implied by other arguments, such as utilitarianism or egalitarianism. To see why, consider someone who is blind or crippled. In the world as it is, he is worse off than most other people. But he is better off than he would be in the much poorer world without private property in land, since in that world he would probably starve to death. Hence, following out the logic of my revised version of Brody's argument, he is owed nothing. On the other hand, the natural primitive, a good athlete with survival skills and little taste for the luxuries of civilization, may actually be worse off than he would be in a world without property in land, and if so is owed compensation even if he is doing pretty well in the world as it is. There are other problems with the implications of the argument. Compensation that only brings the victim of a rights violation back to the level he would be at if the violation had not occurred looks rather like a forced sale at a price based on the lowest the seller would accept rather than the highest the buyer would pay. If I violate your rights in a way that gives me a very large gain, why should you be just barely compensated while I get all of the difference between benefit and cost? If we conclude that the proper rule is something more like an even split of the benefit, we have another problem with my version of Brody's argument. If you were free to make any use you liked of the land my house sits on, you could inflict very large costs on me, so preventing you from doing so gives me a large benefit. If you are entitled to half of that benefit and half of the corresponding benefit to everyone else from your refraining from exercising your right to make use of their land, you have a claim to much more than a per capita share of the world's output. So, along similar lines, does everyone else. I will leave the exploration of other problems with this line of argument, both my version and Brody's original, to readers interested in philosophical excursions, and move on to an approach to justifying property in land that I find, if not entirely satisfactory, at least a little closer. Second try, Locke as revised by Friedman. John Locke famously justified private property in land as due to the owner having mixed his labor with the land. This argument raises at least two problems. One is why mixing your labor with the land gives you the land instead of costing you the labor. As Nozick put it, if I dump a can of soup into the ocean, do I now own the ocean or have I merely lost my soup? A second problem, recognized by Locke, is that if the land starts as equally the property of everyone, my turning it into my property deprives you of the opportunity to turn it into your property. His conclusion was that you were entitled to turn common land into private property only as long as there was as much and as good available for other people to do the same thing with, sometimes described as the Lockean proviso. The problem is that the exception swallows the rule. Since we are eventually going to run out of good land, every appropriator is depriving some later person of the opportunity to himself appropriate. One cannot avoid the problem by claiming that it only arises with the person who wishes to appropriate the last piece of good land. He cannot do so, due to the Lockean proviso. But that means that the next to the last appropriator deprived the last appropriator of the ability to appropriate, so he cannot appropriate either, and so on all the way back to the first. Mathematicians will recognize the form of the argument as mathematical induction applied to moral philosophy. My revised version of Locke's argument starts with the observation that, while the land may, morally speaking, be a commons, I myself am private property mine. You and I have the same right to stand on any particular piece of land. But your right to stand on the land I am currently standing on does not include a right to shove me off, since that is a violation of my property right in my body, that makes the land I am standing on, in a limited and very temporary sense, mine. Similarly, if you happen to have a rifle, you are entitled to use it for target practice on the commons except in my direction, since you do not have a right to shoot me. Following a little further along the same lines, imagine that I find a nice piece of land, pull out the weeds, dig it up, and plant wheat in it. A few weeks later the land has neat rows of little wheat sprouts. I point them out to you and explain that, while you still have a right to go on the land, you do not have a right to crush my wheat plants, since they were produced with my labor and so belong to me. If there is no practical way in which you can go on the land without damaging my property, I have established de facto ownership of that piece of land, at least until my wheat is harvested. I want to make my effective ownership permanent, but wheat is all I want to grow and it only occupies the land part of the year. No problem. I build a fence around my wheat field. The fence may or may not be sufficient to keep you out, but if not, it is probably also not strong enough to survive undamaged your climbing over it. You have a right to be on the land but not a right to damage my fence mine because my labor produced it. We now have a version of Lockean appropriation that solves the usual problems. When I mix my labor with the land I do not acquire any right to the land, but I retain my ownership of my labor and what that labor produced. You are free to use the land in any way that does not injure my property, to dig underneath it for ore, fly your hawk over it to hunt pigeons. But it may well be, depending on what I have done with it, that most of the ways you would want to use it are now barred to you because they would injure my property now mixed with our land. Whether there is as much and as good land available for you is irrelevant, since I am not claiming ownership of any land, merely of what I have mixed with it. This approach to justifying property rights has its problems. In order to maintain ownership of my land I have to be careful to do things with it that make it impractical for anyone else to use it without damaging my property. I have to be particularly careful not to let anyone else do anything with it such that my future use would damage his property, since that could make the land effectively his. That is a cost that could be avoided if the land was my property in a more conventional sense. Speaking as an economist, I find the rules implied by this argument to be inefficient ones. But they at least provide a justification for enforcing a form of property rights in land that is consistent with a libertarian view of rights. Welfare and immigration, the other half of the argument. Many libertarians who favor free immigration in principle have serious reservations about its implications in practice. A Mexican who leaves Mexico to accept a better paying job in the US makes both himself and the rest of us better off, but one who leaves a job in Mexico to go on welfare in the US makes himself better off at our expense. Thus it is sometimes argued that the elimination of barriers to migration only makes sense if we first eliminate government redistribution. One possible response is that present immigrants do not in fact come for welfare and, on average, pay more in taxes than they receive. Julian Simon has made this point and provided a good deal of evidence for it. Its principal weakness is that it describes the people who immigrate under our present immigration laws which make it hard for the sort of people who would go on welfare to immigrate legally and risky for illegal immigrants to apply for welfare. The situation might be different in a regime of free immigration. Back in Chapter 14, I suggested as a possible solution to the problem making immigrants ineligible for welfare for their first 15 years of residence. The argument against immigration takes the level of redistribution as given and points out its effect on who migrates where and why. One should also consider causation in the opposite direction, the effect of migration on levels of redistribution. The harder it is for people to move from one country to another, the more politically attractive redistribution is. The possibility of redistribution tends to increase inefficient migration, but the possibility of migration tends to decrease inefficient redistribution. Consider a government in a world of free migration that is trying to decide whether to increase or decrease the level of welfare. Giving people money may be politically attractive, but collecting the taxes to pay for it is not. A 10% increase in the level will attract indigents from abroad, swell the welfare rolls, and increase costs by much more than 10%. A 10% decrease will cause some indigents presently on welfare to migrate to countries with more generous policies, reducing costs by much more than 10%. The existence of easy migration makes welfare state policies less attractive, with the result that levels of redistribution are likely to be lower. While I have not seen this argument used in discussions of international migration, it is a commonplace in discussions of interstate migration. American supporters of the welfare state routinely argue that welfare ought to be federal rather than state, precisely because state welfare is held down by the threat of interstate migration. Indeed, one possible explanation for why the US moved more slowly than European countries towards a welfare state is that European redistribution was by national governments with control over immigration, whereas American redistribution was largely by state governments without such control. The argument is also relevant to future trends in Europe. The EU is currently moving towards complete freedom of internal migration. If the argument I have given is correct, one result will be to put pressure on national governments to reduce their level of transfer payments. The result will be either a reduction in the European welfare states or a transfer of authority for redistribution from the national to the supranational level. For those who see income redistribution as undesirable, in part because it leads people to divert their efforts away from productive activities into attempts to maximize the transfers they receive and minimize those they pay, this is an argument in favor of free immigration. Those who approve of the welfare state, on the other hand, may see it as an argument against. But they ought to consider that maintaining immigration barriers in order to protect the welfare state means protecting poor Americans at the cost of potential immigrants who are much poorer, reducing national inequality but increasing world inequality. Part 6. New stuff. The poverty of our circumstances in sharp-edged lands where many dwell, all things are true or false, and if you try, a little thought will be enough to tell my truth from your illusion or your lie. From which it follows, as the night the day, since all of us have use of reason's tools, that all who disagree with what I say with certainty are either rogues or fools. I have not found it so. The world I see has honest men with minds as good as mine. I can find reasons that seem good to me, but proofs beyond dispute are hard to find. Problems with Ayn Rand's derivation of ought from is. One of the features of Ayn Rand's writing that first interested me was its claim to overcome David Hume's argument that one cannot deduce ought from is, to reach normative conclusions based only on the objective facts of reality. Looking over her argument as presented in John Galt's speech in Atlas Shrugged, I found it rhetorically impressive but logically mistaken. To show why, I will go through the argument step by step. 1. Existence as the value sought by living things. There is only one fundamental alternative in the universe, existence or non-existence, and it pertains to a single class of entities, to living organisms. But a plant has no choice of action, it acts automatically to further its life, it cannot act for its own destruction. An animal. But so long as it lives, it is unable to ignore its own good, unable to decide to choose the evil and act as its own destroyer. The claim here is that living things other than human beings automatically act for their own survival. That claim is false. A male mantis, for example, mates, even though the final step of the process may consist of being eaten by the female. Female mammals get pregnant even though doing so substantially reduces their chances of survival. If one is going to ascribe values to non-human living things, the purpose of those values, on both empirical and theoretical grounds, is not survival but reproductive success. Of course, survival is usually a means to reproductive success, so most living things most of the time are trying to survive. But a living being that put survival above everything else would not reproduce, so its descendants would not be around for Rand to use as evidence in deriving oughts. Some philosophies might dismiss the facts of evolutionary biology as irrelevant to metaphysical argument. But objectivism claims to base its conclusions on the facts of reality, and the purported fact with which Rand starts her argument is false. 2. Life or death is the fundamental value choice. Since life requires a specific course of action, any other course will destroy it. A being who does not hold his own life as the motive and goal of his actions, is acting on the motive and standard of death. Consider someone following a value other than Rand's, a utilitarian, say, or a nationalist. His life is not the motive and goal of his actions, but it is usually a means to the achievement of his goal. If he is not alive, he can neither have utility himself nor act to increase the utility of others, and similarly if his goal is the triumph of his nation. So such people usually take the actions required by their own survival. But their life is not their goal, as becomes apparent when they have an opportunity to achieve their goal at the cost of their life. Assassinate Hitler, say, with the knowledge that they will die in the process. It is not true that there is a specific course of action required for life and any other course will destroy it. There are a great many different courses of action which preserve life with varying degrees of success. Rand's statement, taken literally, is contradicted by the facts of reality. If such people were acting on the motive and standard of death, they would commit suicide at the first convenient opportunity and there would be nobody but objectivists left. That has not happened. A more charitable interpretation is that Rand means that if you do not take your life as your goal, you are choosing a little death, a slightly higher probability of death, a somewhat shorter life expectancy. That is a true statement, but the equivalent is equally true for any value one might propose. The utilitarian could argue that a non-utilitarian, by not acting in the way that maximizes human happiness, is choosing a little misery. A utilitarian Galt could go on to assert that a being who does not hold the happiness of all men as the motive and goal of his actions is acting on the motive and standard of human misery. His argument would be as good, which is to say as bad, as Rand's. 3. The shift from life to life as man qua man. Man's life is the standard of morality, but your life is its purpose. If existence on earth is your goal, you must choose your actions and values by the standard of that which is proper to man for the purpose of preserving, fulfilling, and enjoying the irreplaceable value which is your life. This passage actually precedes the one I quoted for point 2, this seems fairly clear. My life is the purpose of my morality, so the reason that I must choose a certain sort of morality is that that sort of morality is the best way of preserving, fulfilling, and enjoying my life. The puzzle is where fulfilling and enjoying come from, given that the argument hinges on the choice of existence or non-existence. By the logic so far, fulfilling and enjoying belong in the argument only as means to the goal of preserving. If I can show that your physical survival is enhanced by an act that makes your life less fulfilling and less enjoyable, then, according to the argument up to this point, you should do it. A means cannot trump the end it is a means to. No, you do not have to live as a man. But you cannot live as anything else, and the alternative is the state of a thing unfit for existence, no longer human and less than animal, a thing that knows nothing but pain and drags itself through its span of years in the agony of unthinking self-destruction. At this point, Rand is using passionate oratory to obscure a shift in the argument. She is claiming that someone who lives a full lifespan in the agony of unthinking self-destruction is not really acting for his life. But the fact that he lives a full span of life is evidence that he is not in fact destroying himself. Somehow, something extra has been slipped into the argument to convert life into the kind of life Rand thinks you should live, where the latter is not deducible from the former. 4. The shift from surviving by reason to objectivist ethics. Honesty is the recognition of the fact that the unreal is unreal and can have no value, that neither love nor fame nor cash is a value if obtained by fraud, that an attempt to gain a value by deceiving the mind of others is an act of raising your victims to a position higher than reality, where you become a pawn of their blindness, a slave of their non-thinking and their evasions, while their intelligence, their rationality, become the enemies you have to dread and flee. According to Rand, values are things you act to get and keep. In that sense, cash obtained by fraud is obviously a value for some people. If we interpret value in this passage as meaning value for your life, hence value of the sort Rand is arguing you should seek, it is still puzzling. Money obtained by fraud will pay for just as much food or medical service as money obtained honestly. The rest of the quoted passage is a highly colored exposition of a true point, that if you defraud people, you have to worry about being detected. The problem is that Rand is drawing an absolute conclusion that her argument does not justify. Different opportunities to defraud people have different risks of detection. Victims vary in their ability to retaliate against fraud if they detect it. The implication of the argument is not that one should always be honest, but that one should be prudent in one's dishonesty, which is not, of course, the result Rand wants. To interpose the threat of physical destruction between a man and his perception of reality, is to negate and paralyze his means of survival. To force him to act against his own judgment, is like forcing him to act against his own sight. Whoever, to whatever purpose or extent, initiates the use of force, is a killer acting on the premise of death. To force a man to drop his own mind and to accept your will as a substitute, with a gun, is to attempt to exist in defiance of reality. Using force against someone reduces his ability to use his reason to preserve his life. Reality implies that the victim is less likely to have a long and healthy life. But the coercer is not trying to defy that reality. His objective is not his victim's life but his own. I have pointed out what appear to me to be gaping holes in the chain of reasoning by which Rand starts with the facts of reality and ends with a specific set of ethical prescriptions banning force or fraud. Over many years of argument, I have not yet found anyone able to fill them in. My conclusion is that it cannot be done. For the nearest approximation I can offer, an argument that explains moral behavior but does not, philosophically speaking, justify it, see the next chapter. For my best attempt to justify my moral beliefs, see the chapter after that. The economics of virtue and vice. In the previous chapter I sketched my reasons for rejecting one philosopher's explanation of what virtue is and why we should be virtuous. In this I will offer an economist's explanation of what virtue is and why we, sometimes, are virtuous. And sometimes are not. Starting with the latter. The economics of vice or the rational bully. Two large men meet in a sports bar and get into an argument about the relative virtues of their teams. Half an hour and 6 beers later, one of them is lying dead on the floor and the other is standing over him with a broken beer bottle in his hand and a dazed expression on his face. Is this rational behavior? To see in what sense it might be, consider the discussion of territorial behavior and commitment strategies back in chapter 52. Making good on the commitment, fighting to the death against a trespasser on the territory you claim, turning down your neighbor's modest attempt at extortion, sending a British fleet most of the way to the South Pole to defend the Falklands, is a net loss for you. But if people know you are willing to make good on the commitment you may not have to, because calling you on it is a net loss for them. Similarly here. Imagine that you are big, tough, and, like most people, fond of having your own way. You make it clear to all and sundry that you don't like people disrespecting you and will respond by beating them up. You gradually expand your definition of disrespecting to include flirting with any woman you are interested in or failing to show proper respect for your opinions. Including your opinions about football teams. Actually beating people up can be risky, but most of the time you don't have to, because other people take care not to offend you. A psychologist might describe it as an aggressive personality. To an economist, it is a commitment strategy, one that usually works. One problem is that you may not be the only one following it. One day you walk into your favorite sports bar, sit down next to a stranger, and start telling him how much better your team is than any of the others. He has the audacity to disagree. Half an hour and 6 beers later. To an economist or an evolutionary biologist, the logic of the situation is simple. If nobody else adopts an aggressive personality, the strategy pays, other people do what you want in order to avoid offending you and you never have to make good on your threats. Since it is a profitable strategy, more and more people adopt it. The more people adopt it, the higher the risk of running into someone who will call you on your commitment because he too is committed to a strategy of beating up people who fail to adequately defer to him. In equilibrium, there will be just enough bullies so that, on average, the gain from encounters with wimps who back down just balances the loss from encountering another bully who doesn't. Evolutionary biologists call their version the hawk/dove game. Hawks and doves in their model are two variants of the same bird, differing only in how they behave. When two birds go after the same bit of food, doves back down and hawks don't. In equilibrium, produced this time by Darwinian evolution, there are just enough hawks so that the gain to a hawk from hawk/dove encounters balances, on average, the loss from hawk/hawk encounters. I first encountered the barroom brawl story in a presentation at UCLA many years ago. The presenter's conclusion was that you could not deter such a crime by punishment, since the behavior was irrational and the killer regretted what he had done as soon as he did it. I at one side of the room and Earl Thompson at the other promptly objected that the behavior was indeed rational, seen as the working out of a commitment strategy. One implication is that it is also deterrable. The more severe the punishment is for killing someone under those circumstances, the higher the cost of a hawk/hawk interaction. The higher the cost of a hawk/hawk interaction, the fewer the equilibrium number of hawks. The economics of virtue. There are people, probably many people, who will not steal even if they are certain nobody is watching. Why? My preferred answer starts with the observation that many, although not all, human interactions are voluntary. In deciding whether to hire someone, one relevant consideration is whether he is someone who will steal if not watched. The benefit to the employee of being willing to steal is the amount stolen. The cost to the employer is the amount stolen plus the cost of keeping an eye on the employee in order to hold down that amount. It follows that the cost to the employer is normally greater than the benefit to the employee. It further follows that, if employers could tell which employees were honest and which were not, if the worker's utility function, his preferences with regard to his own behavior, were written on his forehead, the wage premium for honesty would be greater than the fringe benefit of dishonesty, making honesty in the narrow self-interest of the worker. Our utility functions are written on our foreheads, although with a somewhat blurry crayon. Each of us produces, in voice tones, facial expressions, body movements, a stream of information about what is going on inside his head. In order to send a false signal, to persuade people that your preferences are sharply different than they actually are, you have to simultaneously think as the person you actually are in order to decide what to do, for instance when it is safe to steal, and as the person you are pretending to be in order to project the signals that you would be projecting if you were that person. If you require a computer to do twice as many calculations, it slows down. So do we. Most of us are not very good liars. It follows that it is easier, for most of us much easier, to pretend to be honest if we are honest than if we are not. It is in my selfish interest to be thought to be honest. The easiest way of achieving that result is to be honest. Suppose, however, that everyone was honest. It would then not pay employers to make any effort to distinguish those who were from those who only pretended to be, making it possible for a moderately competent liar to collect both the wage premium for honesty and the fringe benefits from dishonesty. The mechanism of equilibrium here is different from the hawk-slash-dove game, but the logic is the same. The more dishonest people there are, the more attention other people pay, hence the lower the payoff to dishonesty. In equilibrium, the number of dishonest people pretending honesty is just large enough to make it in other people's interest to pay just enough attention to keep it down to that number. The best con men take advantage of their talents. For most of the rest of us, honesty pays. This assumes the existence of some mechanism by which the number of honest people responds to the payoff to honesty. That might happen through individuals training themselves into good habits, through parents bringing up their children to be honest, even through evolution if honesty is, to some degree, a heritable trait that pays off in reproductive success. The genetic explanation also suggests why people show their thoughts and feelings on their faces. No doubt the genes could design a human with no facial expressions at all, but who would do business with him? Who would marry him? Just as honesty is valuable in our associates, so is being known to be a bad liar. To simplify my explanation, I have put it in terms of one relationship and one virtue, but the application is much broader. It is better to be married to a spouse who does not cheat on you than to one who does, to work for an employer who does not cheat you, to patronize an honest seller, to rent to an honest tenant. What the argument implies is that, to the extent that you are engaged in voluntary interactions with people who correctly perceive what you will or will not do, it is in your self-interest to be committed to act in ways that maximize the summed benefit to the group of people with whom you are interacting. The value to the other people of dealing with someone so committed, which should show up in the terms they are willing to offer you, is greater than the cost to you. Virtue pays. The punchline. Consider two societies. In one, most associations are voluntary, we choose our jobs, our employees, our spouses. In the other, most associations are chosen for us. The former might be a modern free market society, the latter a centrally planned socialist society where workers are allocated to jobs, or a traditional society where most people are born into a particular role with very limited alternatives. In the market society, since most people who associate with me do so only if they think they benefit by the association, there are costs to being dishonest and benefits to being honest. If you are a worker in a centrally planned society, on the other hand, your job is determined and your salary set by someone far away who does not know you and will not have to associate with you. It follows that the dishonest employee will have the same opportunities as the honest one and the additional opportunity to steal things when nobody is looking. A similar argument applies to vices. One disadvantage to being a bully is that people choose not to associate with you. If, when you apply for a job, you inform the employer that if he does not treat you as you think you should be treated, you will beat him up, you are unlikely to be hired. It follows that the payoff to being a bully will be much lower in a society where most relations are voluntary than in one where most are not. The implication of this argument is that a market society will have nicer people than either a traditional or a centrally planned society. Virtues will have a higher payoff, so more people will be honest. Vices will have a lower payoff, so fewer will be bullies. The result is precisely the opposite of the claim that such a society promotes a blind, narrow selfishness often made by critics of capitalism. An argument I lost, where my moral philosophy comes from. About 50 years ago, when I was an undergraduate at Harvard, I got into an argument with Isaiah Berlin, a philosopher visiting the school. The subject was the nature of normative claims, oughts. My view at the time was that my belief that murdering people was bad had the same logical status as my belief that chocolate ice cream was better than vanilla, that both were statements of tastes rather than objective facts. Berlin's response started by pointing out not how strong the evidence was for normative claims but how weak the evidence was for facts. How do I know that there is not a tiger sitting on my dining room table? It is true I do not see one there, but why is that subjective fact about my perceptions good evidence about reality? His answer was that we believe our perceptions of reality because we have subjected them to all of the consistency tests we have available, and they have, for the most part, Past. Not only do I not see a tiger on the dining room table, I do not see other diners fleeing in terror or commenting on what a handsome beast it is. I do not hear any of the noises I might expect if there was a tiger on the table. If I pass my hand over the table, touch gives me the same result, no tiger as sight. None of this proves that there is not a tiger there, all my senses could be lying to me in a consistent manner. But that is a possibility I have no way of testing. Once my perceptions have passed all the tests available, it is reasonable to act in the belief that what I perceive is really out there, while recognizing the logical possibility that it is not and the more plausible possibility that my perceptions are not perfectly accurate. That brought us to what he argued was the parallel case of normative reality. He offered the following example. You encounter someone who enjoys sticking pins in people. When you ask him to explain his behavior, he tells you that he enjoys the feeling of a pin going into a resilient object, and people happen to be the resilient objects most readily available. After briefly considering the situation, you offer him a rubber ball. He finds it a satisfactory substitute and thanks you for providing him something to stick pins in that does not respond by screaming or hitting him. The point of the example was that while there may be many moral claims, as there are many factual claims, about which people disagree, there are some which pass the same tests as factual claims. There are people who approve of causing other people pain, we call them sadists. There are people who believe that pain may in some circumstances be good for you. But people who believe that human pain is completely irrelevant to judgments of what one should or should not do are about as rare as people who see a tiger sitting on what everyone else perceives to be a bare tabletop. Hence it makes as much sense to describe the former as crazy, as failing to perceive obvious facts, as the latter. A possible response might be that Berlin's example is the exception not the rule, that about most moral propositions there is massive disagreement. That claim, in my view, confuses the moral equivalent of direct observation, a judgment about the moral status of a well-understood and clearly described act, with higher-level claims about moral rules. There is a lot of disagreement about the moral status of private property, intellectual property, government redistribution of income and much else. But then, there is also a lot of disagreement about factual claims at a similar level of abstraction, global warming, the effect of deficit spending on unemployment, what sort of diet is good or bad for you. When it comes to something closer to the normative equivalent of direct perception, we get something much closer to general agreement. That fits my observation of political arguments. While each side may dispute the other's moral position, each also finds it difficult or impossible to accept the factual claims on which the other side's argument is based. It fits my observation of how readers respond to well-written ideological works with which they disagree. The liberal reader's response to Ayn Rand is that she is giving a false picture of the world, not that the world is as she says but her protagonist was wrong to do what he did. Very few people of whatever political persuasion, reading Dickens' A Christmas Carol, see Ebenezer Scrooge Mark I as the hero. The same observation was offered by C.S. Lewis in The Abolition of Man, where he argued that all societies have, at some level of generality, the same moral code, which he referred to as the Tao. The view that I eventually came to as a result of losing my argument with Berlin is what philosophers refer to as intuitionism, the claim that there are facts of moral reality that we perceive via moral intuition just as we perceive the facts of physical reality via our physical senses, and that the evidence for the reality of those facts is the considerable, although not perfect, agreement in how different people perceive them. That is the position that I described, back in chapter 48, as Catholicism without God. My claim is not that we deduce moral reality from physical reality, the claim of Ayn Rand that I disputed back in chapter 59. It is that our knowledge of moral facts comes in the same way as our knowledge of physical facts and so has the same epistemological status, a reasonable, although not in either case certain, basis for belief. Readers interested in a more detailed description and defense of the position, one written by a professional philosopher, will find it in Michael Huemer's Ethical Intuitionism. There is an alternative view of the status of normative beliefs to which I can offer no adequate rebuttal, moral nihilism. According to that position, nothing is good or bad, virtuous or wicked. Moral beliefs are neither true nor false. The consistency of those beliefs, at the level at which they are consistent, is due not to moral reality but evolutionary biology. Humans have evolved those hardwired moral beliefs whose possession led to reproductive success in the environment in which we evolved, along the general lines of the previous chapter. Since we are all descended from ancestors who evolved under roughly similar circumstances, we are all hardwired with about the same beliefs, with the exception of a small minority of defectives, the equivalent of people with the misfortune to be born blind. The blind have the misfortune of being unable to perceive some features of physical reality. Psychopaths have the misfortune, or sometimes the fortune, of failing to share the useful illusions of the rest of us. I do not usually bother to read books arguing for things I already agree with. I read humors largely in the hope that he, as a professional in the field, could provide a better defense of our shared moral philosophy than I could, in particular a better rebuttal to the nihilist alternative. It is a thoughtful and well-written book, but while the author finds his arguments against the nihilist position adequate, I do not. I continue to reject it for two reasons. One is that I have an alternative that I find satisfactory. The other is that I am psychologically unable to actually believe that there is nothing wrong with torturing children or even that there is nothing wrong with telling lies. Rather, as I am unable to believe that what I see is not actually there or that what I do not see, the tiger on the dining room table, is. It may occur to some readers, combining ideas from this chapter with ones from the previous chapter, that the psychopath may not be defective at all. He may be the equivalent of a very tall giraffe whose long neck pays for itself because there are not very many other giraffes competing with him for leaves on high branches. If there are not very many psychopaths, being a psychopath may be profitable. If so, we would expect evolution to deliberately produce some, but not many. Capitalist trucks. One argument against institutions of complete laissez-faire is that government is needed to provide facilities such as roads and sidewalks and to deal with problems such as the conflict between my desire to play loud music at night and my neighbor's desire to sleep. One possible reply is that most such problems can be dealt with by proprietary communities. The developer who builds a group of houses also builds the local streets and sidewalks. Each purchaser receives, along with his house, the right to use the common facilities and to have them maintained, agreeing to pay his share of the cost according to some preset formula. Such private arrangements, which are in fact quite common, can deal with externalities as well. My colleague Gordon Tullock used to point out that he could not repaint his front door without the permission of his neighbors, that being one of the terms of the contract for that particular community. When the same arrangement is packed into a single building, the contract is likely to include procedures for resolving disputes among neighbors as to what behavior in one apartment inflicts unreasonable costs on the residents of adjacent apartments. In any proprietary community, the contract is likely to contain arrangements by which the signatories can jointly modify it to deal with new circumstances. In what sense is that not a government? As a British acquaintance put it to me, his relationship with his condominium association and his local authority are essentially the same. Each has authority over his behavior as a result of his decision to live in a particular place, an apartment in the condominium in the local authority. Each imposes rules on him. Each taxes him, although the condominium does not call the money it collects for maintenance and repairs taxes. Each can change its rules by similar methods, a vote of his fellow citizens in the one case, his fellow residents in the other. While the condominium association may be a solution to certain problems, in what sense is it a private solution? To turn the argument around, if libertarians approve of such institutions when they are called condominium associations or proprietary communities, why do we disapprove of them when they are called governments? A possible answer is that the proprietary community, unlike the government, came into existence without violating anyone's rights. The developer bought the land from its owners and resold it to purchasers who had agreed to the government-like restrictions included in the purchase contract. The local government, on the other hand, came into existence because, at some point in the past, a majority of the inhabitants, or possibly a majority of the citizens of some larger political body within which it is located, or possibly someone with a bigger army than anyone else, decided to create it, imposing their rules on everyone already living there whether or not he agreed. That is a possible answer, but I do not think it is one likely to convince many non-libertarians. There is a different answer that does not depend on a libertarian view of rights. There are practical reasons why the way in which institutions came into existence matters, quite aside from the question of whether anyone's rights were violated in the process. To see what those reasons are, consider the following question: you wish to buy a truck, and have a choice of two. One was built in Detroit, one was built in Naberezhny Chelny. Which do you choose? Most people would choose the capitalist truck. Why? Both are trucks. If they are identically built, they should function in exactly the same way. Why does their history matter? Why should we care about the ideology of a truck? The answer is that the two trucks are not identically built. The capitalist truck was built under a system of institutions in which people who build bad trucks are likely to lose money. The communist truck was built under institutions in which people who build good trucks are likely to lose money, and often other things as well, since insisting on building only good trucks may result in not meeting your assigned quota for the month. Even before checking out the trucks, we have a good reason to expect that the communist truck will be worse built. Among other things, it may well be heavier, since quotas were sometimes set not in number of trucks but in tons of trucks. The same answer can be made for the difference between a condominium or proprietary community and the government within which it is located. The private developer who created the former had a private incentive to design the best possible political institutions. The more attractive the community association appeared to the purchaser, the higher the price he would be willing to pay for the house. Voters also want to live under desirable institutions, so the political entrepreneur who is creating a new local government or modifying an old one also has some incentive to try to create attractive institutions, but a much weaker one. There are reasons why democracy does not work nearly as well as capitalism. The individual voter has little incentive to try to find out whether proposed political changes are actually in his interest, since his vote has only a small chance of determining what actually happens. The individual purchaser, on the other hand, votes by buying or not buying a house in the community. If he does not buy, he will not be under that community association's rules; if he does, he will, so he has a substantial incentive to investigate the institutions before buying or to check out current property values and the current condition of common facilities in previous communities sold by the same developer. One important characteristic of a government is its size. The average American lives under a local government ruling at least tens of thousands, perhaps hundreds of thousands, of citizens. The average inhabitant of a condominium or proprietary community, I would guess, lives under a private government of about 100 citizens. I doubt this is an accident. My suspicion is that local governments are bigger than proprietary communities for much the same reason that communist trucks are heavier than capitalist trucks. Perverse incentives. The preference for capitalist trucks is not merely a matter of libertarian ideology. A sensible communist would also prefer capitalist trucks. Communists who had the opportunity to shop in the West, an opportunity frequently given as a reward for party loyalty and other communist virtues, routinely demonstrated their preference for capitalist goods by buying them in as large a quantity as possible. More recently, what used to be the communist world has demonstrated its preference for capitalist trucks on a somewhat larger scale. The conservative mistake. Critics of free immigration worry that immigrants might make the country more socialist, more crime-ridden, more like the places they are coming from, but offer no strong reason to expect those particular effects. Leaving the place where you grew up to move somewhere very different is, after all, evidence that you prefer the latter. As I pointed out in one exchange, the Volokh brothers, associated with the popular libertarian/conservative legal blog The Volokh Conspiracy, are immigrants from the ex-Soviet Union. While Eugene and Sasha Volokh are slightly more socialist than I am, they are much less socialist than most of their fellow academics, not entirely surprising given that they have experienced socialism at first hand. The same assumption, that change is presumptively bad, appears in arguments over global warming. It seems likely that the average temperature of the globe will go up by several degrees C over the next 100 years due mostly to increased carbon dioxide in the atmosphere. If I had to guess, my guess would be that the net effect of the change will be positive, for at least two reasons. The first is that human habitability is limited mostly by cold, not heat. The equator is populated, the poles are not. The second is that, for well understood reasons, global warming can be expected to increase temperatures more in cold places and at cold times than in warm. Combine those two and one might guess that a somewhat warmer world would be, on the whole, more suited to humans, not less. Yet most people discussing the issue take it for granted that the change is bad, indeed catastrophically bad. A similar pattern holds for a variety of other issues, from fracking to cloning to GMO foods. I call it a mistake, but perhaps that is unfair. The present is at least tolerable, since we are at present tolerating it. A change might make things better, might make them worse, so why chance it? That sounds like a plausible argument, but it contains a hidden assumption that stasis is an option, that if we do not have more immigration our cultural and political circumstances will remain the same, that without anthropogenic CO2, climate will stay what it currently is. Both are demonstrably false. Over my lifetime the cultural and political institutions of the US have changed for reasons that had little to do with immigration. Over the past million years, the climate of the Earth has changed radically time after time for reasons that had nothing to do with anthropogenic CO2. A rise in sea level of a foot or two would create problems in some parts of the world, but not problems comparable to the effect of half a mile of ice over the present locations of Chicago and London. The left-wing version of the conservative mistake comes with its own pseudo-scientific slogan, the precautionary principle. It is the rule that no decision should be made unless one can be confident that it will not have substantial bad effects, that the lack of a reason to expect it have such effects is not enough. It sounds plausible, merely a matter of playing safe, but a moment's thought should convince you that it is not merely wrong, it is internally incoherent. The decision to permit nuclear power could have substantial bad effects. The decision not to permit nuclear power could also have substantial bad effects. If one takes the precautionary principle seriously, one is obligated to neither permit nor forbid nuclear power, and similarly with many other choices, including acting or not acting to prevent global warming. Continuing with that example, I have long argued, only partly in jest, that the precautionary principle is a major source of global warming. Nuclear power is the one source of power that does not produce CO2 and can be expanded more or less without limit. A major factor restricting the growth of nuclear power has been the precautionary principle, even if not always under that name, hostility to permitting reactors to be built as long as there is any chance that anything could go wrong. That example demonstrates my more general point: stasis is not an option. The world is going to change whether or not we permit nuclear power. There is no a priori reason to expect the changes if we permit it to be worse than those if we do not. I am not arguing that there is never a good reason to fear change. Sometimes a change can be reasonably predicted to have bad consequences. I am arguing that much opposition to change, across a wide range of different topics and disputes, is based on the mistaken assumption that if only that particular change is prevented, the next year, the next decade, the next century, will be more or less the same as the present. That is very unlikely. The misuse of externality arguments. If you want workers to work in your steel mill, you have to offer them terms at least as attractive as their next best option. If you want coal and ore, you have to offer the miners at least what it costs them to get it out of the ground. The costs of producing steel are thus transferred from the people who provide your inputs to you. Similarly, the value of what you produce is transferred from your customers to you in what they pay you for your steel. If the value of what you produce is more than the cost, it pays you to produce it and you do. If value is less than cost, it does not pay you to produce it and you don't. That is a short version. The long version requires a year of price theory and / or a good textbook of why a market society produces things if and only if they are worth producing. There is, however, a problem. In addition to consuming labor, ore, and coal and producing steel, you also produce sulfur dioxide, which makes things less pleasant for those who breathe downwind of you. That is a cost of producing steel, but, in a society without the EPA, tort law, or anything similar, it is a cost for other people, not you. In such a society, it may pay you to produce steel even if total cost, pollution included, is greater than total benefit. Similarly, if you produce external benefits for other people, such as the pleasure passers-by will take in looking at your beautiful building, you will ignore those benefits in deciding whether to build it. Economists refer to such effects as externalities: negative, external costs, and positive, external benefits. Their existence is one of the arguments economists offer for government interventions in the market. Air pollution is a negative externality, so regulate or tax it. Knowledge produced by basic scientific research is a positive externality, so subsidize it. The argument is correct in theory. Externalities are one source of what I described in Chapter 53 as market failure. A government that forces people to take account of them can, in principle, improve on the result of the unregulated market. There is, however, a practical problem. In order to do the job properly, the government needs to know the sign and size of the externality. Without that information, they might provide the wrong tax or the wrong subsidy. They might even tax something they ought to subsidize or subsidize something they ought to tax. Currently, the problem that the experts insist must be solved, immediately if not sooner, is global warming. 40 years ago it was population. It was widely asserted then that the more people there were on Earth, the worse off we would all be. Quite a number of people went further, claiming that we were facing immediate catastrophe. In The Population Bomb, published in 1968, Paul Ehrlich wrote that the battle to feed all of humanity is over. In the 1970s, hundreds of millions of people will starve to death in spite of any crash programs embarked upon now. At this late date, nothing can prevent a substantial increase in the world death rate. While his position was more extreme than that of many others, his work was taken seriously. Less extreme versions were as widely accepted then as concerns about global warming are now. My first piece of published economics was a pamphlet written for the Population Council at the request of its president. He observed that almost all discussion of the issue was coming from one side of the ideological spectrum and wondered how the question would look from a different viewpoint, so asked me to write a piece on population issues from a pro-market point of view. The question was one of externalities: if one more child was born, were other people worse off as a result, and if so, by how much? My conclusion was that not only could I not tell how large the externality was, I could not even tell whether it was on net negative or positive. Nor, as best I could tell, could anyone else, although quite a lot of people thought they could. Increases in population have both positive and negative effects. More people means more people to create pollution and commit crimes, more people to go on welfare, but also more people to make inventions, pay taxes, write books, and compose music. The effects in both directions are large and, since they are spread over a long and uncertain future, very hard to estimate. The simple argument for the conventional view, that more people meant less land and natural resources for each, was simply bad economics, at least in the context of a private property society. A newborn baby does not arrive with a deed to his per capita share of the world's resources clutched in his fist. If I want my child to own land on which to live, either he or I will have to produce something of value that the present owner of that land is willing to accept in exchange. Some other arguments went in both directions. The more children, the greater the cost of putting them through the public schools, a cost not borne directly by their parents. Children, however, grow up to be taxpayers. Match up the cost of schooling each child with the taxes he will later pay for schools and the two roughly cancel, making a net externality close to zero. Some externalities are clearly positive. More people means less of the national debt for each to pay. Some are clearly negative. Overall, I did not see how one could estimate the externalities, positive and negative, accurately enough to sign the sum. Many years later, I encountered the same problem in the context of global warming. Most of the public argument was about whether global temperature was going up, whether the reason was carbon dioxide produced by human activity, and how large future warming was likely to be. Practically everyone took it for granted that warming was a bad thing, probably a very bad thing. I could not and cannot see why. The current climate was not designed for us nor we for it, global climate having varied quite a lot over the history of our species. Humans presently live and prosper across a range of climates much larger than the predicted change. The only a priori reason I could see to expect change to be bad was that we are currently optimized to our current environment. That might be a serious problem for rapid change. But the global warming being projected was at a rate of about 1/3 of a degree centigrade per decade. That should be more than slow enough to let farmers adjust their crops, homeowners their housing, at little cost. If we cannot produce an a priori reason to expect warming to produce net negative externalities, perhaps we can work out the consequences and simply add up their cost. Warming can be expected to raise sea levels a foot or two by the end of the century. It can also be expected to push temperature contours in the northern hemisphere hundreds of miles farther north, increasing the area of Earth warm enough for human habitation by about 1,000 times the area lost to sea level rise. On average, the land gained would be less valuable per square mile than the land lost, but would one expect it to be 1,000 times less valuable? Warming will have other effects, negative and positive. Since we are talking about effects over a period of a century or more, William Nordhaus, an economist who has specialized in studying the warming issue, runs one of his calculations out for 250 years. It is impossible to make any reliable estimate of their size. Readers interested in a longer discussion of my reasons for thinking that the net effects are at least as likely to be positive as negative will find it on my blog. My point here is a more general one, an explanation of why the attempt to base policy on estimates of external costs and benefits led to mistaken conclusions about population 50 years ago and very dubious conclusions about global warming today. Consider someone adding up externalities in order to decide what public policy should be, whether government should encourage or discourage population growth, tax carbon, or subsidize it. If he believes that the net effect of warming is negative, he is likely to make generous estimates of the negative externalities, conservative estimates of the positive, and miss some of the latter because he is not looking very hard for them. He ends up honestly convinced that the objective evidence supports the position he started with. If he starts with the opposite belief, his calculations will have the opposite bias and he will reach the opposite result. A few years ago, I came across a striking example of this pattern in the work of William Nordhaus. His research on the effects of global warming found negative externalities sufficient to justify imposing a carbon tax to slow it, although both the externalities he found and the measures he proposed were modest compared to the views of some other researchers, still more so compared to the views of activists such as Al Gore. To get even that modest result, he had to include in his estimate of costs not only predictable effects such as sea level rise but low probability effects that, if they did occur, would impose large costs. In a book co-authored with Joseph Boyer, the authors wrote that this approach is taken because of the finding of the first-generation studies that the impacts on market sectors are likely to be relatively limited. Or in other words, without including the costs from unlikely but catastrophic risks, global warming did not seem to be a serious problem. There is a curious asymmetry to their approach. They took account of low probability high cost consequences of permitting global warming. But, so far as I could tell, they made no similar attempt to take account of low probability, high cost consequences of preventing global warming. That might make sense if we could be confident that, absent the effects of human action, climate would never change. But we have no grounds for such confidence, since climate has been changing, sometimes quite radically, since long before human beings were able to influence it. We are currently in an interglacial, a relatively warm period within the Ice Age that began more than 2 million years ago. We do not know what causes interglacials to start or end. Long-term estimates of global temperature suggest that it has been trending slowly down for a very long time, possibly since the beginning of the current interglacial, a trend reversed by current warming. It is at least possible that global warming is all that is preventing the interglacial from ending. The result of its doing so, judging by past glaciations, would be a drop in sea level of more than 300 feet, leaving every seaport in the world high and dry. Also half a mile or so of ice over the present locations of London and Chicago. I do not think that catastrophe is likely, but it is possible, and there may be other unlikely but possible catastrophes that have not occurred to me. Nordhaus, looking for negative effects of global warming, included the unlikely ones. He did not, so far as I can tell from that book, a later one, or correspondence with him when writing this chapter. I wanted to make sure that I had not misread his work include any estimate of unlikely effects in the other direction. I take that as evidence of the problem with using externality arguments to produce policy conclusions. When balancing costs and benefits, it is only too easy, without even trying, to put a thumb on the scale. It is even easier when you are trying. Many years ago, when I was a graduate student, I spent a summer as a congressional intern. My congressman lent me out for 4 days a week to the Joint Economic Committee. They lent me to their project on state and local finance, aka the State and Local Finance Project of George Washington University, aka the State and Local Finance Project of the Governor's Conference. Exact titles by memory so possibly wrong, it having been something over 40 years ago. The project was producing a fact book, a volume designed to inform the interested layman of the facts relevant to issues in state and local finance. I discovered a fact. It was a demographic fact about people already born, so clearly true. It was a fact relevant to the largest part of the budget of state and local governments, so clearly relevant to the subject of the book we were producing. The fact had to do with the ratio between the school-age population and the tax-paying population. For the previous decade, as the children of the baby boom came into the school system, that ratio had been going up. That meant that maintaining a constant level of per-pupil expenditure required increasing tax rates. Over the next decade, the baby boom was coming out of the schools and into the labor force. That meant that the ratio of school children to taxpayers was going down. That in turn meant that the same level of per-pupil expenditure could be maintained with lower taxes. The people running the project agreed that my fact was true. They did not deny that it was relevant. But they refused to include it in their fact book because it pointed in the wrong direction. They wanted to argue that states and localities would need more tax money in the future. I was offering evidence that they would need less. I was young, innocent, and shocked. Here were intelligent people I liked and respected, professional academics, deliberately doing dishonest work. Since then I have been disinclined to take on faith conclusions that come out of academic work on public policy. Unschooling, a libertarian approach to children. The conventional model of K-12 schooling is based on two assumptions, both wrong. The first is that, out of all the world's knowledge, there is some subset about the right size to fill K-12 that everyone should learn, or at least be exposed to. The second is that the way to educate children is to sit them down and tell them what some authorities, typically teacher and textbook, have decided they should know. The first assumption is, I think, not only mistaken but indefensible. Most people will find the ability to read and write and do arithmetic useful. Most will not find the ability to do trigonometry useful. Geometry and algebra, part of the standard curriculum, will be useful to some, but probability theory or statistics, not usually included, will be more useful to others. Biology is an interesting subject, but it is not clear that the amount of biology that most students learn in high school is of more use to them than the amount of economics they could learn in the same amount of time. American history teaches some useful lessons, although, given the inevitable biases of any one source of information, some of the lessons will probably not be true. But Roman history, or Greek history, or British history also has lessons. And, as some evidence of how much American history students actually learn, the man who is, as I write this, Vice President of the U.S., asserted in a television interview that when the stock market crashed, FDR got on television to speak to the nation. In 1929, when the crash occurred, Herbert Hoover was president and television still in its early stages of development. As further evidence of how much of the curriculum actually gets learned, consider my wife's experience teaching geology labs as a graduate student. She was at VPI, probably the second best state university in Virginia, which meant that her students were drawn from about the top quarter of high school graduates. A sizable minority of them did not know that the volume of a rectangular ore body was height times width times depth. The second assumption is also wrong. As all students and most teachers know, the usual result of making someone study something of no interest to him is that he memorizes as much as he has to in order to pass the course and then forgets it as rapidly as possible thereafter. People learn things much more easily and remember them longer if they are things they want to learn. Consider the case of a child who actually gets interested in something, whether D&D, batting averages, or dinosaurs. Museum of Natural History volunteer to almost 2-year-old in his mother's arms, pointing at an arrangement of 2 dinosaur skeletons. What do you think that is? Albertosaurus et Iambiosaurus. True story. He was still having trouble with LS at the time. Not only is the assumption about how children learn wrong, it teaches a dangerous lesson that the way to find out what is true is to locate an authority and believe what he tells you. One of the crucial intellectual skills is the ability to judge sources of information on internal evidence, to learn to distinguish between an author or speaker who cares whether what he says is true and one who does not. The conventional model of schooling anti-teaches that skill. The student is presented with 2 authorities, teacher and textbook, and, unless the teacher is unusually good, expected to believe them. Quite often, judged at least by my experience, that is a mistake. Much of what is taught in school is not true. When the 2 children of my second marriage approached schooling age, my wife and I faced a decision. I had gone to a first-rate private school, my wife to a good suburban public school. Each of us had had a few good teachers and classes, but what we most remembered was being bored most of the time. I learned more about the English language reading Kipling's poetry for fun and going through a book or 2 a day, largely Agatha Christie and her competitors, during summer vacation, than I did in English class. I learned more about political philosophy arguing politics with my best friend than I did in social science. My wife learned geology, a subject not much taught in school, following her geologist father around rock outcrops and mineral shows. We both agreed that we ought to be able to do better for our children. Our solution was unschooling, first in a small and very unconventional private school and then, when problems developed with that, at home. In the school, students controlled their own time. Classes occurred only if the students went to a staff member and asked to be taught something. Later, at home, there were no classes, just books, conversation, unlimited internet access. When our daughter decided she wanted to learn to play harp, we found her a teacher. She audited several of my law school classes. When she decided to learn Italian, we arranged for her to take advantage of a program at the university where I teach that let high school age students enroll in college courses over the summer. She worked harder than I can ever remember working at a class, high school or college, took advantage of not being in school to take 2 more quarters of Italian during the year, ended up majoring in Italian in college. I like to describe unschooling as throwing books at kids and seeing which ones stick. Early on, both our children read How to Lie with Statistics, a good popular book on how not to be fooled by bad statistical arguments. Our son liked D&D and similar games, so was interested in learning probability theory. It turned out that the author and illustrator of How to Lie with Statistics had a book on that subject too, How to Take a Chance. We may have ended up with the only 11-year-old in town who could calculate the probability of rolling 5 or less with 2 6-sided dice. Our daughter's reading included The Selfish Gene, a biography of Talleyrand, and much else. One Christmas the children got Game Boys with Pokemon cartridges. I heard a radio talk show host, commenting on high-tech toys, observe that children played with them for an hour or 2 and then got bored. Ours must have logged easily 40 hours a month, possibly 40 hours a week, for many months after getting those Game Boys. From one point of view they were learning a useless skill, since neither Pokemon nor the world they live in are real. From another point of view, they were learning the useful skill of how, dropped into a new environment, one figures out how to find one's way around and function in it. The amount of intellectual energy they put into doing so was enormously greater than what children, judged again by my observation, are willing to put into schoolwork, learning things other people have told them to learn. My wife taught our daughter to read with the help of books by Dr. Seuss designed for that purpose, including a subversive tract entitled Hop on Pop. It took a few weeks. Her brother, 3 years younger, observed and taught himself. We discovered that he had also taught himself to type when we were playing Diablo on the house network and misspelled words started appearing on the screen. They eventually stopped being misspelled because he did not want the people he was playing StarCraft with online to think he was stupid. At a somewhat later stage, our daughter practiced her writing skills composing battle reports for World of Warcraft encounters. When the children were little, home unschooling meant that one of us always had to be home. Then and later it meant being willing to talk with our children more or less without limit and point them at books or subjects they might be interested in. My wife and I took turns putting the children to bed, spending about half an hour each evening doing it. I recited poetry or made up stories, she sang or told incidents from her childhood, both of us talked with them about whatever they wanted. The nearest we came to anything like a required class was nagging them into learning the multiplication tables, which our daughter, now an adult, thinks was a mistake. Judged by our experience, unschooling not only saved our children from having to spend a substantial part of every week sitting in class being bored, it also gave them a better education. There were parts of the standard curriculum that they never learned or learned less well than they would have at a good school, most notably mathematics, which neither of them found all that interesting. Some of the holes in their education they filled by studying for the SAT exams, which they wanted to do well on so that they could get into the sort of college they wanted to go to. Some were never filled and probably never will be. On the other hand, they ended up learning a great deal more about a wide range of other subjects, from evolutionary biology to economics to history, than they would have in a conventional school. If at some future point they discover that they need something that was left out of their education, they can learn it then, a more efficient strategy than trying to learn everything they might ever find useful, most of which they won't. And a strategy that works better for people who have grown up educating themselves than for people who have grown up being schooled. Perhaps more important, they did not learn that education was something rather like cod liver oil, good for you but bad tasting, or that reading books is something you do because you are assigned to do it. When my daughter got to college, she was shocked to discover that when her favorite class was cancelled for a day, the other students were glad instead of disappointed. One of her chief objections to the college experience was that it was not real. She was spending time writing papers that would be read by only one person and only because it was his job. Oberlin, where she spent 2 years before transferring to the University of Chicago, has a 1-month winter term during which students can do a project of their own invention with the approval of a professor, not necessarily on campus. During her second year she came home for that month and translated a 15th century Italian cookbook. That was real. It is now on the web. Lessons from reality. One argument I have seen offered against unschooling is that, in the real world, you sometimes have to do things you don't like, a lesson we can teach our children by making them study things they are not currently interested in studying. It is an interesting point, and I think reflects a serious error. One way of teaching children about the real world is to construct a synthetic world designed to imitate the real one. To teach them that they will sometimes have to work to accomplish things even if they do not want to, we assign them homework they are not interested in doing and reward them with grades. If grades don't work well enough, we reward good grades with cash, as some parents do. What this approach leaves out is the causal connection between the work and the accomplishment. Someone else has told you to do unpleasant work, someone else will reward you for doing it, but there is, from your standpoint, no logical connection between the two. Doing homework does not, so far as you can tell, actually produce money. The alternative to a synthetic world is a real world, the one we and our children are living in. If you do not tune your harp, it will not sound very nice when you play it. If you do not tidy up your room at least occasionally, you will not be able to find things you want. If you do not sometimes do things your younger brother wants you to do, he will not do things you want him to do. That world also teaches the lesson that getting what you want sometimes requires doing things you would rather not do. And it gets the causal connection right. For a year or two, our son was running a weekly D&D game for some of his friends. That meant that, each week, he had to spend time preparing that week's adventure and get it done before his players showed up. He did. I do not want to overstate my claim. Unschooling worked for us, but 2 very bright children brought up by highly educated parents are not exactly a random sample of the relevant population. There is evidence that it works for quite a lot of other people. Interested readers may want to look at the literature on Sudbury Valley School, the model that the school where our children started their unschooling experience was built on. There may be some children who would learn more in a conventional school, even children who would enjoy the process more. But, judging by our experience, unschooling, home unschooling if no suitable school is available, is an option well worth considering. An argument against homeschooling. And for it. Homeschooling and unschooling fit well together, but they are not the same thing. Much homeschooling follows a conventional model, complete with curriculum, textbooks, and exams. Unschooling can be done in a school. Sudbury Valley School has been doing it for more than 40 years. This chapter is mostly about unschooling, but since we were also homeschooling, I think it is worth saying a little about that as well. One criticism of homeschooling is that homeschooled children fail to be properly socialized due to insufficient exposure to others of their own age. There is some truth to this. Homeschooled children can and do get together with other homeschooled children or, in contexts such as Boy Scouts or church, with children who are in school. But they are likely to interact less with their peers and more with their family than if they went to school. When our daughter arrived at Oberlin, American teen culture was an alien world to her, with the result that she made some adult friends but none of her own age. On the other hand, she was more comfortable with adult society, including her teachers, than most of her fellow students. The year before she went to college, when she was taking Italian classes at the same university where I teach, she spent a lot of time in office hours. Her professor's comment to me was that it was wonderful to have a student who really challenged him. Consider the standard model from the standpoint not of education but of socialization. It is rigidly age-segregated. Almost all the people a student associates with at school, with the exception of the teachers, are the same age. A 15-year-old does not have to prove that he is stronger or smarter than a 10-year-old. A 10-year-old does. The model of social interaction that comes out of that environment, a world where everyone is in direct competition with everyone else, is not an entirely attractive one. Nor very good training for life in an age-mixed world. Judith Harris, in her very interesting The Nurture Assumption, argues that how children are brought up by their parents usually has little effect on their adult personality. Her explanation is that humans are good at realizing that different environments have different social rules. The child at home adapts to the social rules of the parental environment, at school to the rules of the peer group environment. It is the peer group version that ends up forming most of the adult personality. Harris mentions, as an unusual special case, children for whom the family is the peer group. Homeschooling might be one way of getting there. If so, the socialization argument cuts in both directions. Having my children end up with personalities rather like those of myself and my wife rather than personalities modeled on mass American society strikes me as a plus, not a minus. I suspect that many who criticize homeschooling along these lines are working from the unstated assumption that the home culture is worse than the school culture, probably that the typical homeschooling parent is an uneducated Christian fundamentalist trying to protect his children from being taught evolution. Such evidence as we have suggests that that is wrong, that homeschooling parents are somewhat better educated than average, not worse, and that religious concerns are not their most important motive. The critics might reach a different conclusion if they were imagining homeschooling as they themselves would do it. One more point about homeschooling is that whether it works may depend in large part on the relation between parents and children. If they do not get along, something unfortunately pretty common, it might work very poorly. Of course, one reason they might not get along, although not the only possible reason, is that the children have been socialized in school into viewing their peers as us and adults as them. Welcome to the future. You want to send someone a message that nobody else can read. The solution is encryption, some way of scrambling the message before you send it that the recipient can reverse. To do that he will need a key, a description of how to unscramble the message. There is a problem with this solution if we are talking not about communications between a government and its embassies but between ordinary people, including ones who have never met each other. If I do not have a safe way of sending a message, I may not have a safe way of sending a key. If someone intercepts the key en route and copies it, he will be able to read my future messages. The solution, invented some decades ago, is public key encryption. It depends on a mathematical procedure that generates a pair of keys with a special relationship. A message encrypted with one key requires the other to decrypt it. One of them, your public key, you send to all and sundry, publish online, make as widely known as possible. The other, your private key, never leaves your control. Anyone can now write a message that only you can read by encrypting it with your public key, to be decrypted with the private key that only you have. If a spy has a copy of your public key, he can send you secret messages too. But he cannot read messages other people send you, even if he succeeds in intercepting them, because doing that requires the private key. Public key encryption not only solves the problem of secure communication over channels that may be monitored by other people, it also solves the problem of proving your identity at long distance. Suppose I want to send a message to a stranger and prove that it is really from me. I encrypt the message with my private key, add an unencrypted note saying that it is encrypted with my private key, encrypt message plus note with his public key, and send it to him. He decrypts with his private key, reads the note, then decrypts the message using my public key. He now knows that the message was encrypted by someone who possessed the private key that matches my public key, hence that it is from me. That is the essence of how digital signatures work. Suppose the intended recipient does not know my public key but does have the public key of some organization that both of us consider reliable: American Express, the Catholic Church, the Electronic Freedom Foundation. I go to that organization, show them my public key and my identification documents. They write me a digital certificate stating that this public key belongs to the David D. Friedman who teaches at Santa Clara University and is the author of The Machinery of Freedom. They sign it using their private key. I attach the certificate to my signed message and send it. The recipient checks the signature on the certificate using the public key posted on the door of every American Express office in the world. He now knows my public key. If I do not entirely trust American Express, I send him separate certificates from a half-dozen different authorities. Unless they are all working for the National Security Agency, I should be safe. What if what I want to prove is not my real space identity but my cyberspace identity, that I am the same online persona he has interacted with before? That persona is associated with the public key he used to encrypt the messages he sent it. I prove my online identity by using the matching private key to sign the messages I send him. As this example demonstrates, public key encryption not only makes possible secure communications, it can also make it possible to combine reputation with anonymity, to have an online persona with a reputation without having to tell anyone in the world, including those you deal with as that persona, who you are, how old you are, or what continent you live on. There are still two ways in which an observer, possibly from the IRS or the NSA, might identify you. One is by observing where emails come from and go to. The other, assuming that you are engaged in economic transactions online, is by following the flow of money. Public key encryption makes countermeasures possible. The solution to traffic analysis is an anonymous remailer. You encrypt your message with the public key of the intended recipient, add a note with his email address, encrypt the whole thing with the public key of the remailer, and send it to them. The remailer strips off the top layer of encryption, reads the email address and forwards the message. The remailer has thousands of messages coming in and thousands coming out. Incoming and outgoing cannot be matched up since they differ by one layer of encryption. Even an observer who can see every message, who sent it, and who received it, cannot link the original sender to the final recipient. What if the remailer has been taken over by whomever you are trying to keep the information from? For that problem too there is a solution. The forwarding address of your email is not that of the recipient but of another remailer. Stripping off the top layer of encryption reveals that address and exposes a second layer of encryption, this time done with the second remailer's public key. Bounce your message through 10 remailers on its way to the intended recipient and, unless all 10 are owned by the same bad guys, no observer can link sender to recipient. The problem of online payments can be solved by another application of encryption technology, anonymous digital cash, a technology first worked out by David Friedman, a Dutch cryptographer. It is a way in which one person can make a payment to another by sending him a message without either party having to know the identity of the other and without the bank holding the money knowing the identity of either. Readers sufficiently interested and with a sufficient mathematical background should be able to find the mathematical details with a little online searching. For the rest I offer a low-tech version. Low-tech anonymous e-cash. I randomly create a very long number. I put the number in a dollar bill in an envelope and mail it to the First Bank of Cyber Cash. The FBC is committed to do two things with any money it receives in this way. 1. If anyone walks into the FBC and presents the number, he gets the dollar bill associated with that number. 2. If the FBC receives a message that includes the number associated with a dollar bill it has on deposit, instructing the FBC to change it to a new number, it will make the change and post the fact of the transaction, not including the new number, on a publicly observable bulletin board. The dollar bill will now be associated with the new number. Alice has sent the FBC a dollar accompanied by the number 59,372, actually a much longer number, to make it harder for other people to guess it. I'm simplifying. She now wants to buy $1 worth of digital images from Bill, so she emails the number to him in payment. Bill emails the FBC, sending them three numbers, 59,372, 21,754, and 46,629. The FBC checks to see if it has a dollar on deposit with number 59,372, it does. It changes the number associated with that dollar bill to 21,754, bill's second number. Simultaneously, it posts on a publicly observable bulletin board the statement the transaction identified by 46,629 has gone through. Bill reads that message, which tells him that Alice really had a dollar bill on deposit and it is now his, so he emails her a dollar's worth of digital images. Alice no longer has a dollar, the FBC no longer has a dollar associated with the number she knows, so if she tries to spend it again the bank will report that it is not there to be spent. Bill now has a dollar, since the dollar that Alice originally sent in is now associated with a new number and only he and the bank know what it is. He is in precisely the same situation that Alice was in before the transaction, so he can now spend the dollar to buy something from someone else. Like an ordinary paper dollar, the dollar of e-cash passes from hand to hand. Eventually someone who has it decides he wants a dollar of ordinary cash instead, he takes his number, the number that Alice's original dollar is now associated with, to the FBC and exchanges it for a dollar bill. It may be low-tech, but it meets all of the requirements. Payment is made by sending a message. Payer and payee need know nothing about the other's identity beyond the address to send the message to. The bank need know nothing about either party. When the dollar bill originally came in, the letter had no name on it, only an identifying number. Each time it changed hands, the bank received an email but no information about who sent it. Even if the bank identifies the person who finally comes in for the dollar, he has no way of tracing it back up the chain. The virtual dollar is just as anonymous as the paper dollars in my wallet. A world of strong privacy. Imagine that public key encryption for secure communication and identity, a network of digital remailers, and some form of anonymous digital cash are all in common use. Further suppose that technologies such as virtual reality are far enough developed so that many people spend large parts of their lives interacting online. The result is a world, cyberspace, with a level of privacy humans have never known. It is hard to tax what you cannot see. If you earn money in real space and spend it online, the government can tax your income. If you earn money online but spend it in real space, the government can tax your spending. If you earn money online and spend it online, both income and expenditure are invisible to the IRS. It is hard to regulate what you cannot see. Suppose I want to sell legal advice, despite not being a member of the bar. I create a website and an online identity, Legal Eagle Online. Also a public key. I spend the next year building my reputation by offering legal advice for free, good legal advice, as those who take it discover. Thereafter I charge for it, accepting payment in digital cash. I am violating state licensing rules. But since the Bar Association has no idea who I am or where I live, there is no way they can enforce those rules against me. Generalize those examples and you have a world where governments control real space but cyberspace is stateless. Force and fraud, law enforcement in an online anarchy. Force is mostly not an option in cyberspace, the internet protocols do not provide for the transmission of bullets. To kill someone in real space, even to arrest him, you have to know who he is. Fraud remains a problem. Consider contracts. I hire you to write me a computer program. If I pay in advance I may never get the program. If you code in advance you may never get paid. The solution is reputational enforcement. You are not willing to code in advance unless I have a history of performing on my contracts in the past, a history linked to my online identity and a reputation that will be at risk if I receive the program and then refuse to pay for it. I am not willing to pay in advance unless you have such a reputation. To make it work, we need some way in which interested third parties, people who might want to do business with one of us in the future, can tell, if a dispute arises, which of us cheated. The solution is arbitration. Our contract, digitally signed by each of us using his private key, includes the public key of the arbitrator that we have agreed to. If a dispute arises, the arbitrator decides which of us owes what to the other. If the losing party fails to pay, the arbitrator writes up a statement to that effect, digitally signs it with his private key, and gives the signed document to the prevailing party to post on a web page with the other party's name all over it. Anyone who wants to check the reputation of the losing party does a web search, finds the document, and discovers that that party cannot be trusted to abide by the decision of the arbitrator he himself chose. He can verify that by checking the digital signatures. No further research required. What if neither party has a reputation to lose? They rent the reputation of a third party, an escrow agency. Each makes a deposit with the escrow agency and agrees that it will forfeit to the other if the arbitrator they have agreed on so rules. Readers are invited to think through for themselves further problems that might arise and how they might be dealt with. Getting there. Everything I have described so far we have known how to do for several decades now. Public key encryption is widely used to protect online commerce, but the infrastructure has not developed to the point where everyone has a key pair, where digital certificates are routinely used to link public key to real space identity, where a large fraction of online communication is protected by end-to-end encryption and sent through digital remailers. Anonymous eCash was proposed by Chom in 1990 but does not yet exist, probably because it requires a trusted bank. Banks are heavily regulated, and the existence of anonymous eCash would eliminate an important tool of law enforcement. That last may be changing, thanks to the introduction of a different sort of eCash called Bitcoin. Bitcoin is not only not anonymous, it is the least anonymous form of money that has ever existed, since every transaction is visible to every holder of Bitcoins. But the transaction is identified by an account, not a real space identity, and it is apparently possible, by adding procedures analogous to anonymous remailers, to delink payment and receipt, converting it into a fully anonymous currency. Its great advantage over Chom's version is that it does not require a trusted issuer. Readers interested in details can investigate them online. An adequate treatment would take a fair fraction of another book. The problems produced by the lack of the rest of the infrastructure were demonstrated in 2013 by Snowden's revelations about the activities of the National Security Agency. Not only was it getting information from the phone companies about who called whom when, it was monitoring online activity on a large scale, in part by legal search warrants, in part by methods whose legality depended on a secret interpretation of the relevant statutes, in part by activities that, if Snowden's account was correct, were flatly illegal. One feature of criminal law in the US at present is that only the government can prosecute it, which is convenient for criminals who commit crimes that the government approves of. Widespread adoption of end-to-end public key encryption and the use of anonymous remailers would make impossible most of what the NSA has been doing, although they could still go after inadequately protected private keys, perhaps by hacking into the computers that held them. No security system that I know of is safe against human error. Exploiting such error has been, in the past, a central feature of successful intrusion. Revelation of what the NSA has been up to has increased the pressure for action by firms and individuals to protect online privacy, but there remains a practical problem. For most of us, encrypting our email only pays if most of the people we interact with are part of the public key infrastructure, with key pairs and the necessary software. As long as they are not, we will not, and as long as we do not, they won't. A further problem is that encryption and anonymous remailers only protect privacy if lots of people are using them. As long as there are only a few, using them puts you at risk of being identified as having something to hide. A future of strong privacy online is possible but far from certain. In my Future Imperfect, where I discussed these issues at greater length, I paired them with a technological development in the opposite direction: surveillance. The combination of inexpensive video recorders, face recognition software and database technology could create, arguably is creating, what David Brin called the transparent society, a world where everything that happens in public places is recorded and findable. Fast forward a little further to the point where inexpensive video cameras are available with the size and aerodynamics of mosquitoes, and transparency may not be limited to public places. Imagine a future where cyberspace has more privacy than we have ever known, real space less. How private or public that world is will depend on how much of our life is lived in cyberspace and how well we can protect our connection to cyberspace from real space surveillance. It does no good to protect your email with strong encryption if a video mosquito is watching you type. Welcome to the future. This chapter is dedicated to Tim May, a founder of the cypherpunk mailing list where many of these issues were raised and argued out some 20 years ago, and to Werner Ving, computer scientist and science fiction author, whose story True Names, published in 1981, pointed out the possibilities of online anonymity.